It's just coming up to 10 o'clock. Welcome back. I think we've probably seen lots of you before and maybe some new faces too. So it's time for us to open this hearing session. So this is the start of the stage 2 hearing sessions. So they follow on from the stage 1 hearing sessions held some time ago. There's quite a lot of things happened in the meantime. I've asked the council to update on that after I've done our opening, to kind of give a little summary of where things are up to. So we won't today be going over the sort of stuff that we went over at stage 1. We've sort of moved on from that and we're looking at the new evidence that's now been provided. And that corresponds to the letters that we've sent in this gap, this pause in the examination, which most of you will have seen are on the website. So as you know, my name's Louise Crosby and I'm sat next to me today is Elaine Worthington. We're both inspectors appointed by the Secretary of State under Section 20 of the Planning and Compulsory Purchase Act 2004 to carry out the independent examination of Shropshire Local Plan. We shall refer to the document as the plan during the hearing sessions. Can everybody hear me? I should have checked probably before. Yeah, okay. Not very well. Okay. Well, apparently I was going to come on to that. Apparently they work from some distance. They somehow know how, I don't know. Is there whereabouts are the outputs? Is it better if people are struggling to hear that they sit in a certain place, or?
I suspect that might be the case, but I'm speaking at this distance. Can people hear me okay from this distance? So maybe this is the
optimum
distance. Yes, about that far.
Right, okay. I'll bring the microphone a little bit closer. They are better than the old-fashioned sort with a big microphone head on them, but yeah, is that better? Can you hear better now? Yeah, okay. So most people have spoken to Kerry Truman, the programme officer for the examination dealing with administrative matters. Her and her colleague Ian Bussey are here today, sat to the left of us, and they're your first point of contact if you've got any queries about the procedures for the hearing session or the examination generally. So they'll be based here for the duration of the hearing sessions, at least in the day anyway, and out of hours they tend to pick up emails and things. So if you've got a problem attending or whatever, if you let them know, they'll pick those up. Just a few housekeeping points. So as we already alluded to, the microphones apparently pick up from some distance and adjust the sound to however quiet or loud your voice is apparently. But so I don't think there's microphones for every single person, so you might have to just sort of move them along a little bit if you're wanting to speak. But I think they should be ample for us to be able to, for everybody to be able to use them. To turn them on and off, it's the right hand button. Quite simple, turn it on and off. I have the master thing, so if people leave them on and they need turning off, I can do that. And be very careful. Apparently they're quite sensitive, so they do pick up noise quite easily, so be careful if you want to be heard, put the microphone on. If you don't want to be heard, turn it off. And particularly because it's been recorded is the session, and the sound comes from the microphone, so it's important we all use the microphones, but equally you might not want what you're telling your colleague next to you broadcast to everybody on YouTube. So just be wary of that. I'll make sure they're all turned off in the breaks and things. So I think that's probably it in terms of microphones. We'll just see how we go with them, but I don't think there's much more we can say about those. The lighting's not brilliant. We've tried to get the lighting turned up a bit today, but it's still a bit dim. I think this is the best we're going to get, so we'll just have to sort of do the best we can. And the heating, again, I think it's quite warm in here, but apparently it's extreme, so if the heating goes off then we'll all be shivering. So I think it's one of those rooms again where it's quite an old building probably, and we'll just have to sort of manage best we can, but we are monitoring the heating. If you want to take jackets off, if it makes you feel more comfortable, then feel free to do that to help manage the heat situation. Is the press here at all? No? Okay. There's no planned fire alarm. The test was yesterday, so if it goes off, it's the real thing. If you follow the fire exit signs, there's one behind you, and probably some council will explain anyway. If we're in the event of a fire, we'll follow Mr. West and his team out of the building. Toilets are off the main landing. Hopefully most of you found those. If you've parked in the car park, you will need to register your registration number on the computer. So if you've not done that, you might need to dash out and do that. Otherwise, I suspect you might get a ticket. There is Wi-Fi. Has everybody managed to connect, or does anybody need any help with that? No? Okay, right. So as I said, the council are recording the sessions and then uploading them to their website. So they'll record it throughout the day and then they'll be uploaded immediately after the session. So anybody, if you want to view sessions that you're not here in person at, you can do that. Or if you want to rewatch anything, then that's available to you as well. Does anybody object to being filmed? No. We're all pretty used to it now, aren't we? It's fairly standard. Okay, so our role in conducting the examination is to determine whether the submitted plan satisfies legal and procedural requirements under the 2004 Act as amended and the 2011 Localism Act and associated regulations, and whether it is sound. To be sound, the plan must be positively prepared, justified, effective and consistent with national policy. The starting point for the examination is that the council has submitted what it considers to be a sound plan. So if we conclude that the plan is not sound, we need to consider whether any modifications could make it so. So this is the stage 2, as I've said, of the part of the hearing. So these first 2 weeks will cover more strategic matters, and principally it's the new evidence that's arisen. That will be the main focus. And then the latter 3 weeks will deal with site allocations, development management policies, and things like 5-year housing land supply, which is easier to assess once we've looked at individual sites. So there are guidance notes that are on the examination website, and they explain more about the examination. We've identified a number of matters and issues for this stage of the hearings to be investigated, taking into account representations made on the plan and the additional evidence. The hearings which start today will be based on these matters and issues. There are some main modifications that the council have already started a sort of rolling programme of, and the latest version is on GC4M, so that superseded the previous GC4M document. And as far as I know, the latest version is dated July 2024. So these and any further main modifications that arise out of the hearing sessions are likely to need consulting upon, and further essay work might be required at the end of the final hearing sessions too. And just ask the council to keep a running schedule of changes it proposes, supports, or has no objections. So any that we discuss throughout the hearing sessions as before, we'll just all keep a note and cross-reference at the end of the day, make sure none of us have missed anything. So a timetable for the hearing sessions has been produced along with a list of those participating, and that's on the examination website. The sessions are open to the public to observe, but only participants around the table are able to speak. Also, the hearing sessions, excuse me, are not an opportunity for you to introduce new points that were not included in your Regulation 19 statement or in response to the council's subsequent consultation. We stress that we won't be hearing evidence about emission sites. Should we find that the council need to allocate more sites, then it'll be for the council to identify those sites and test them. So the sessions which start are set out in the programme and agendas. There'll be a mid-morning, mid-afternoon break each day, as well as a lunch break, and that'll vary slightly. The breaks, we'll just take a break when it seems appropriate in proceedings. The lunch break today will break at 1 o'clock for lunch for an hour, and on subsequent days, because we're starting at 9:30, we'll break for lunch at 12:30 till 1:30. But as I say, the mid breaks will be a little bit more. They'll move a little bit. We stress that people should be seated around the table and ready to take part in the session at the allocated time and return promptly from breaks. So the hearing sessions will be relaxed and informal discussions focusing on particular matters being considered. We've produced agendas which hopefully you've all seen. They're very much based on our original matters and questions paper. There is a few extra questions we've added in as we've started to read statements and things. So we'll be asking a series of questions and asking the council and others to contribute as appropriate. Everyone will be given an adequate opportunity to speak if they wish to do so. Different sessions might run slightly differently. I think for this week, we've got quite a lot of people around the table. So what I propose to do is that we'll sort of go around in order and let people speak. So, for example, when we get to the essay, we'll just deal with that in the round, and we'll go around the table rather than back and forth between lots of people. That gets quite confusing, I find, with lots of people, and some people find they don't have a chance to say as much as they want to do. So that's how we'll run that session. But ultimately, we'll make sure everybody has an opportunity to say everything they want to say before we leave, and the council have an opportunity to respond, etc. As we get further along into the hearing sessions and there's less people, we'll do it in a more traditional sort of round table where it's slightly easier to do that with less people. So you don't need to repeat comments from statements or comments that others have already said. So the fact that 20 people say the same thing doesn't mean it carries more weight. We listen to everything that everybody's got to say, even if it's one person, then we still take account of it. So that's about it for the initial announcements. In a moment, I'll ask the council to make an opening statement, and then we'll run through the items on the agenda in turn. Has anybody got any questions before we start, or any problems with attendance, or no? Okay. Great. So if did it mean Mr. West that's...
Yes, it is. Thank you, Inspector Crosby, and welcome everyone to the Shirehall. I just want to touch upon the admin points about the fire exit, just in case, because you alluded to that, it will be out that way, and we will reconvene in the car park outside. So it's, as Inspector Crosby says, just follow me on that one, okay? I'll be first out the building, I assure you. So just opening statement. So obviously Inspector Crosby's obviously already alluded to a few of the time frame and the communications that the council have had over the course of the last 18 months. If I just take you back over that slightly again, and just to I suppose clarify where the council is with its new evidence and how it's got to that kind of area. I don't intend to talk about the intricacies of that at all. That's obviously for the hearing sessions to do that. I'm just going to talk about it's the timeline and what's on the table here from our perspective on that case. And clearly, over the course of this week and next, we'll have ample opportunity to have a conversation about that new evidence. So, following the stage one hearing sessions, which took place in July 22 and early 2023, which focused on legal, procedural and strategic matters. The inspectors obviously issued their interim letter in early 2023. That obviously allowed the examination to carry on. It confirmed that we'd met the duty, which is obviously a legal hurdle, which we were confirmed that we had met that. But clearly there was some pieces of evidence and additional work which the inspectors, I suppose, wanted the council to, happen in order for the examination to carry on. The timeline around that's quite interesting as well, and that's probably why there's a bit of an explanation here for people who haven't been part of the process up to this point, why it's taken quite a while to get to this point. There was a process of letters from ourselves to the inspectorate and back, which sought to clarify the scope and remit of the additional work which was required. That culminated in the inspector's letter early on this year, which is ID 30. It's 37, ID 37, apologies. That's available on the council website. We felt as a council that provided the clarity we needed to do the additional work, which we feel is obviously before the examination here today. So just to briefly recap on what that additional work is. So we have undertaken additional essay work, we have updated a paper on housing and employment land requirement. We've updated Greenbelt paper as well, and we have also produced a new draft policy on housing provision for older people and for people with more specialist needs. So those 4 items, those 4 pieces of new evidence were consulted on between April and June this year, in line with the council's the community involvement, and we obviously read and all the responses. There was over 300 responses were made on that. Again, they are all available on the council web pages. So again, obviously the reason why we're here today and over today and next week is principally to have conversation around this new evidence, around what it indicates. Just to briefly overview the essay, which obviously we are going to be having a conversation about later today and this morning, that has sought to assess a number of options around potentially revising the employment and housing requirements for Shropshire over the plan. We looked at reasonable options for the uplift of any needs consistent with the kind of earlier iterations of the essay, and specifically, and this obviously came out through the discussions at the stage 1 hearing sessions, we have specifically sought to include an essay of the unmet needs that we are proposing to meet from the West Midlands area, in the Wolverhampton Walsall area of that area, which is the 1,500 and the 30 hectares. So the essay seeks to consider reasonable options around that. The culmination of that exercise has led the council to propose to the examination an increase in the employment and housing requirements for the local plan, and that is obviously before us today. So the proposal from the council, which is the culmination of the additional essay exercise and the further considerations we considered through the topic papers, which again are all available online. This proposes a preferred strategy for the housing requirement to increase by up to 31 300 dwellings over the course of the plan, and the employment requirement to increase to 320 hectares over the plan. So that's a marginal uplift from the plan which we originally proposed and was before the inspectors and the hearing sessions, obviously. So this continues the high growth proposal which we had proposed in earlier versions of the plan, but takes specific account of the unmet requirements from adjoining councils, which we've agreed through statements of common ground as part of that process. So that is effectively as well as the uplift to the local housing need. As well as that, we've looked at options. Again, this goes back to the specific requirements set out in the inspector's original interim letter around the request that the council identify specific land for the unmet requirements to be met. We have done that. We have taken that through the essay process, and we've assessed a range of available options, which we consider are the reasonable options available for that process. And we've culminated in that, and the conclusions of that are in the topic paper. So for the avoidance of doubt, the council are not proposing at this stage of the examination any additional allocations to meet the proposed uplift in housing and employment requirements. Our preference and our proposal through the essay process and through assessment of reasonable options to do that is to accommodate that uplift through windfall through windfall proposals over the course of the plan. That's sort of a very brief overview of where we've got to, and so it was just one thing to just clarify, I think, on this as well. The statement of common ground that we have with the ABCA authorities was updated very recently. In fact, was incorporated onto the website, I believe, yesterday. So there's an addendum which you may not have viewed yet, but that addendum is now available on the website. That reconfirms the agreement made through the duty process of the level of unmet need that we are proposing to accept and to incorporate into the local plan, and the manner in which that unmet need is delivered through the local plan. So that is a very recent addendum that is on the website, but I just want to make sure that everyone was aware that was there. So I won't say any more for this time, but that's sort of, I suppose, an overview of where we've got to, unless there's any specific questions you had at this time, Inspector Crosby or Inspector Worthington, we can.
Thank you. I'll come on to some questions in a moment. So probably worth clarifying. So Ms Worthington and I are we've sort of divvied up the work, if you like. So some sessions I'll be leading and some Ms Worthington will be leading. So you'll obviously see that happen throughout the course of the examination. Just something I think it might be worth pointing out, Mr West, for everybody's benefit, because it's a fairly recent change, and I'm just thinking everybody might not have picked it up, but the council's identification now in terms of site SHR 166 and the historic England stance on that, just because it's sort of cross-cutting, although it's a specific site, it cuts across numbers. And
that's a very fair point, Inspector Crosby. I think, yes, just so everyone is aware, for those of you who were involved in the stage 1 hearing sessions, probably heard representations from Historic England as well on that point. SHR 166 is the proposed site allocation for employment land purposes to the west of Shrewsbury, east of Shrewsbury. Get my east and my west mixed up. Good start. The east of Shrewsbury for 45 hectares of employment land. Subsequent to the submission of the local plan in 2021, September 2021, Historic England, through the minister, agreed that it's a minister for culture, isn't it, at that point, agreed that there would be a scheduling of a significant proportion of the site. So that I think occurred in November 22 on that one. So since that point, there's effectively been a scheduled monument on that location. So we've, as part of the process and as part of the recent matters statements which the council have put in to support the this hearing sessions, we have agreed with further conversations with Historic England that we are asking the examination to recommend that site be removed from the plan. I think that's the way the phraseology. So so we have come to the conclusion through that place. So effectively, that is in our matters report on that point. It's included within the matter for Shrewsbury around the justification around the site allocations around that. But yeah, as Inspector Crosby says, it has cross-cutting impacts, particularly around issues like employment land supply as well. And I think we're coming on to that in matter 4, I think it is, isn't it? So I think, yeah, so yeah, I think that is an important point actually. That has obviously also led to Historic England and Shropshire Council agreeing an addendum to the Statement of Common Ground, where Historic England are proposing that their objection be removed on the basis that site is also removed from the plan. And again, that Statement of Common Ground update is on the website as well, I believe. So that is, and again, purely for the points of clarification, for clarification here, that is the only site at this point where the council are asking the examination to consider removing from the local plan process. Okay. I just wonder, Inspector Crosby, it's also worth mentioning about Natural England, or shall we leave that till this afternoon?
In terms of an update from them. So we could mention it now, and then we'll be this afternoon. Worthington's dealing with the HRA this afternoon.
Yeah, I think it's just worth pointing out, because obviously we have obviously had also conversations with Natural England specifically around the issue of development within the Clun catchment. That I think is going to be a separate issue, but just be aware that there is an update to the Statement of Common Ground, and we consider and have agreed through that process that Natural England have removed their objection to the plan on the basis of the proposed main modifications that the council are proposing for this examination.
Thank you. Yeah, that's helpful. I thought it was just worth flagging because there's so much volume of material, isn't it? People can easily miss things. So that's the SHR 166 is a sort of changing circumstance, really, isn't it? That means that the council no longer recommending that site is kept in the plan, and that'll be something we need to consider as part of the examination, because obviously only we can recommend that sites be added or taken out of the plan. So it's on that basis that the council have approached it. Okay, just one other thing just to mention, or just to clarify before we move on, and that was, I think it came maybe from Mr. Charles in your statement about the clarification on note ID 44. So that was a note that we issued about numbers, and just so that it's clear, maybe it wasn't clear from the note that we did. It was intended to clarify matters in light of the recent consultation of government on the revised MPPF and figures and things. So we were just being clear, really, that we're not considering those are numbers for the future. It's out to consultation. Nobody knows what the numbers will finally be. Yeah, you read into it what you want to, whatever. But the numbers we're working with are the numbers, the LHN from 2020, I think it was. Keep changing numbers at this point as well, just confuses matters even more and delays the plan making process and things. So is that clear? That
I don't think it was me, Mom, but I'm happy to take the credit.
Maybe it was your colleague from Savills. It was your colleague from Savills, right? Yeah. So yeah, it was just a clarify, and for anybody else that was wondering about it. So we will be discussing numbers and the requirement, etc., because there's lots of comments around that. But we didn't want to get into this doubling of numbers that the government are proposing. That's for a future examination and plan, etc. Okay, thank you. Okay, so as I've alluded to already, I think the easiest thing with the essay is there's 4 separate questions, but it's easy just to deal with it in the round, because that's kind of what happens anyway. We go through the questions, and by the time you get to the last one, there's nothing left to say because it's all been dealt with already. So I think it's just easier to talk about the essay in general terms, and particularly when we've got quite a lot of people around the table as well. So I've got some questions really about the numbers and things, just to clarify points, and we'll go through those, and I'll ask some questions of the council, and then a lot of the comments that people have made about reasonable alternatives, I think I'll leave that for other people to sort of put those points, because you're much more au fait with what your particular concerns are and which sites you're concerned about and the scoring, etc., etc. So we'll deal with it on that basis. As Mr. West has already explained, there are some key letters, I suppose, from us that have been sent to the council since the last hearing session. So that was probably ID 28 and ID 36, which deal with various matters that are linked back to this. So ask them to do certain work, and explained in fairly a lot of detail in some points what we expected from them. So in terms of questions, so I'll run through them one by one and get the council to answer, and then I'll turn to people to speak, and if you want to pick up on any of those matters you speak, then that's fine. I might have already covered things I think that probably lots of you were going to say anyway. That's why it felt quite a good way to sort of deal with it in the round, because it's lots of things we've picked up as we've read statements and things. So the first question is around the growth option that was assessed. So it assessed a lower amount of housing for Shropshire itself compared to the original essay. So, and I think that's what a lot of the comments about, and it was things that we covered in our letters, were about the requirement for Shropshire. So effectively the requirement's been reduced to create more housing or employment land for the Black Country, effectively, hasn't it? So it's sort of been subsumed still to some degree into the requirement figure. The supply's another issue, but and so as I said, that was something we specifically asked the council not to do in previous letters, and particularly in ID 36. And also the plan at para 3.47 says that the amount of 30,800, so obviously that number's gone up now, is essential for the long-term prosperity of Shropshire. So that was just talking about the Shropshire numbers. Do you want to come back on that? I've got various other questions, but I won't just sort of reel them all off because that's probably not helpful to anybody.
Yeah, thank you, Inspector Crosby. I think I'll start, and then perhaps my colleague, Mr. Corden, will can elaborate. We thought, in terms of the growth options which were assessed in terms of the updated essay, we very much took a lead from the note or the letter which you prepared in clarity to ID 36, which was published early on this year. So that's the letter which I alluded to in my openings, 37, ID 37. Bear with me 1 second. I'll just find a copy of that.
Could have mentioned that number as well, yeah.
Yeah, sorry. Yeah, obviously, ID 37 was your clarification to a number of points that we had following ID 36, where we were requesting clarity on a number of points, and the growth options which we assessed were effectively in line with, or we believe was in line with your clarification point at that point. So taking the local housing need at 2020, and that's quite an important point here, I think, as the basis for local housing need for the plan. The growth options being iterations of that, be 5, 10, 15% above the local housing need at 2020, and then layering on the 1,500 unmet need on top of that. So not consumed within that, that will be on top of that. So effectively, we sought to assess as close as possible the original options from way back in the issues and options about what those were. The difference here in terms of numbers is the starting place with the local housing need assessment. Obviously, when we assessed the original essay against the issues and options in 2017, that we didn't have the benefit of the 2020 baseline at that point. Obviously, the updated position, we do have that benefit, and we believe that is what you were advising us to do. That you do then lead on to slightly different numbers coming on the back of that, in effect, because the local housing need between that time had slightly reduced, effectively. So the starting point had slightly reduced, but the actual growth options themselves, which were assessed, were consistent with those original growth options, i.e. moderate, significant and high growth. The preference being through that process, and the conclusion of that process on both occasions was for high growth. The updated essay, rather than consuming the unmet need within that, specifically looked at options that went high need plus 1500, and the high growth plus 1500 is the option which we are recommending to this examination for consideration. So we don't necessarily do consider it, and I'm sure there'll be a conversation here today about that. Or we don't think that there is a consumption of the unmet requirement need, into the Shropshire housing need and growth options. We feel as though it's very much as well as that, and I think that's quite clearly set out within our both the essay options and the topic paper we presented. I just wonder if there's anything you wanted to add there.
Yeah, just to reiterate, the options that were assessed within the additional essay work consisted of, they all utilised the 2020 LHN as the baseline, and then each option included a 5, 10 or 15% uplift, and then each option was looked at with and without an additional 1,500 contribution specifically for the Black Country contribution. We consider that approach is very much aligned with para 5.7 of ID 37, where we were seeking clarification in terms of which options we should be looking at through this process. So we consider the approach we've utilised allowed for consideration of all reasonable options and has informed our recommendations in terms of which housing requirement we should proceed with.
May I just add, sorry, because we've focused on housing. The same process was effectively undertaken for employment land requirements as well. The same principle around that. I think probably, just if I may, probably the best way of showing this, there are two in the topic paper which we produced, which is GC 45. There are two tables, and I should have this marked. So apologies if you bear with me 1 second. But I think it's quite helpful for the discussion just to emphasise what we did. So for employment land need and requirement, it's 18.1, figure 18.1 on page 163. And for housing, it's figure 11.1 on page 82 of the updated topic paper. Those two figures, I think, are quite a useful indication of the process or the flowchart of what we did in terms of assessing options and the outcome of that process and where those various bits come in. So I'll pause there.
But we think that we have done precisely what paragraph 5.7 of ID 37, which was your helpful clarification note, suggested we do. I.e., test the options based on the 2020 baseline with 2 extra years, growth options of 5, 10 and 15% uplift.
And 1,500.
And then add 1,500. Yeah.
So in effect, you get the 3 options with variations of each 3 option, one with the 1,500 uplift and one without the 1,500 uplift, because obviously that's a matter for the examination to conclude about whether the unmet need should be incorporated in, which is why we assess the options with and without the unmet need.
I haven't got the actual, I've got a summary of those documents in front of me. So as I've got it here, so the original essay was GC 44, wasn't it? The
GC 44 is the additional essay assessment that we've undertaken. The original essay is SD 006.01 to 00.
Sorry, yeah, my mistake. So in the original essay, which was ENV 006.01, so as I understand it, the high growth option was 1,437 dwellings per annum. That was the figure that was tested. Sorry, a memory test.
If you bear with us 1 second.
Yeah.
Yeah, I think it was That's you're correct. The original option 3, high growth, which was originally over the 20 years, but it based on a yearly basis, it doesn't, obviously an annual basis, it doesn't matter, was 1 for, yes, 37, 1 for 37. That the, again, just purely to explain this is in the difference of numbers. It comes down to the local housing need at that point in time. Obviously, that SA was based upon local housing need at the point of preparation at that point, which was, so we were relying on 2016 data at that point to justify the baseline position, I suppose, in the local housing need. In terms of the updated position, which is the 2020 local housing need, the difference between the two is that there was a reduction in local housing need between 2016 and 2020. So you end up, when you obviously, fairly obvious maths, if you add 15% onto a lower figure, you get a lower figure at that point. But the point being is that in terms of what the SA has sought to do, the highest, or I suppose the largest option which we considered through the additional SA work is the 2020 baseline position plus 15%, which represents high growth and consistent with the original preferred option and the submitted plan. In terms of a strategy, maybe not numbers, but the strategy is the same, plus 1,500 on top of that. So again, whilst the numbers change at the end, the point being the way it's worked out is actually we do not consider as a council, our position is the 1,500 is in any way consumed within the Shropshire need at that point, because it was a specific requirement on top of local housing need plus 15%. Basically, the difference is local housing need baseline.
Okay, so that explains that, but that still doesn't explain that in the plan as submitted, it was about, I've tried to do it in dwellings per annum because that was easier because of these 2 years. It makes it easier to work out, doesn't it? So that was around 1,400 a year in the submitted plan, wasn't it?
I believe it was, yes. Yeah, it was.
Yeah.
1,400.
No,
Or 1,400, yeah, no, 1,400.
1,400 in the
These
submission.
numbers, I wrote them all down before I came. So and then, but now what's being proposed is in effect, as I understand it, is 1,422 for Shropshire plus Black Country. So in terms of Shropshire, that's 1,354. So that's an overall reduction in requirement for Shropshire. That's kind of what.
Well, in numerical terms, it's a reduction in requirement, but again, the point being, it relates to the reason why it's a reduction in requirement, because the baseline local housing need from when we began the Reg 18 process, when we originally did the SA process in has changed. I see where you're getting to in terms of actually the submitted plan. You have a reduction on that, but when you factor in the 2020 baseline, which is I believe what we were asked to do through ID 37 plus 15%, you get to a number.
So was the original plan not based on the 2020 LHN? That was my understanding.
So the original 3 options assessed within the SA work were based on the 2016 LHN.
Yeah, but the submitted plan.
Yeah, so the 2020 assessment, the 2020 LHN underpinned the submission version of the plan, but it didn't inform the actual options that were assessed within the original SA.
Right. Okay.
It was more than 15%.
Exactly.
Yeah. Effectively, yeah.
Yeah. Growth in the submitted plan was more than 15%. It was nearly 19%.
Yes.
It was nearly 19%.
Yeah, I think the issue is, isn't it, that the numbers, if you're just looking at raw numbers as a layperson, the numbers have gone down for Shropshire
Yes.
in now compared to the submitted plan that was
Yes.
the one that we've got in front of us as the original plan.
Yeah, so I mean, ultimately, the strategy was a high growth strategy in order to achieve various issues and objectives. And the strategy continues to be a high growth strategy in order to achieve those issues and objectives, plus a specific consideration of the 1,500 contribution to the Black Country. So the strategy continues to be high growth based on the 2020 LHN. And as I think we just reiterate the fact that the council considers the options it's assessed are the reasonable options, and the identification of those options were consistent and informed by ID 37, in particular paragraph 5.7.
Thank you. That's helpful background understanding to where some of these. It gets more complicated as time goes on with these plans, doesn't it? It's. What else was I going to say? Just let me have a look through the points that I wanted to raise before I open it up to everybody else. Yeah, similar with employment land, isn't it? We don't need to go through all the numbers, but the principle is the same across the board. So then sites that were tested through the essay to meet the Black Country need. So obviously you've identified specific sites to meet that need, which is what we asked you to do. So this was done on the basis of no new sites, is it? So you just looked at the existing sort of pot, or did you sort of look wider into other sites that you've maybe looked at previously and see whether any of those were suitable?
Yeah, so just to confirm the methodology, initially we identified an assessment area. We considered proximity and connectivity to the Black Country, migration and commuting patterns and travel to work areas. And through that, we identified a reasonable assessment geography within which we considered all reasonable options for potential sites to accommodate the contributions would be located. In short, effectively, it was the eastern and central parts of Shropshire. We then assessed every site that we'd identified throughout the process, not just proposed allocations, but all sites within that geography, in order to identify those sites we considered were appropriate to accommodate those contributions of 1,500 dwellings and 30 hectares of employment land. Through that process, 4 proposed sites were identified. They are all existing proposed allocations. However, we would suggest that's perhaps unsurprising because they were identified themselves through a proportionate site assessment process. And those sites are all located within the reasonable assessment geography, and we consider are all appropriate to accommodate contributions to the Black Country. And obviously the recent additional statement to common ground with the Black Country authorities has agreed that those sites are appropriate for that purpose.
And at that time, did the council consider adding any more sites in, so additional sites to meet effectively the additional unmet need from the Black Country, and so identifying either more sites to meet Shropshire or different sites to meet the Black Country need?
Yeah, so in the context of the exercise to meet the Black Country needs, the specific sites, we considered all sites within that assessment geography. We considered those and we identified those sites we felt were appropriate for that purpose.
So all candidate sites, when Mr. Corden says all sites were looked at, not just allocated sites, but unallocated sites.
Correct.
Within that reasonable assessment geography area.
So was any concept?
But it happens that the 4 sites selected were already existing allocations. So those were identified for the Black Country. The next question is, does that mean you need to allocate any more sites for Shropshire? Which is what Mr. Corden is going to come to next.
Yes, so for that process, again, we looked at the options to accommodate the uplift to the housing requirements through the sustainability appraisal process summarised in GC 44. We effectively looked at four options. The first was the use of windfall to accommodate that uplift. The second was the intensification or densification of proposed allocations. The third option was either extending existing allocations or identifying new allocations. And the fourth option was a combination of the above. Through that process, we identified option A, option 1, the windfall allowance as appropriate. In sustainability appraisal terms, it was considered the most sustainable. Within the housing and employment topic paper, we then undertook a planning judgment exercise, which considered the results of the essay, but also considered factors such as consistency with our wider strategy and deliverability, because what we didn't want to do is have a strategy that's not deliverable. And through that process, it was concluded that that was the most appropriate option. And we've identified 3 specific locations where windfall allowances through site guidelines have been proposed to be increased in order to accommodate that uplift to the housing requirements. Those locations are Shrewsbury, Whitchurch, and the former Ironbridge Power Station.
Okay, thank you. That's helpful. But obviously, you can't influence windfalls. We all know that they just happen where they happen to some degree.
I would argue that the policy mechanisms within the plan facilitate windfall development. So the approach in the policies can dictate the level of windfall that occurs in Shropshire. Our strategy is one that facilitates windfall, and as do a number of policies in our plan. For instance, our approach to affordable housing and our approach to development within development boundaries facilitates appropriate windfall development taking place.
There may be some confusion, and it's very important to avoid it, about the use of the term windfall in this context. Quite often, windfall sites are those which are obviously not allocated, because that's a definition of a windfall site, one that isn't allocated. But sometimes allowances are made for windfalls because you don't know the sites that the windfalls will come forward on. I'm going to sound a bit like Donald Rumsfeld now. But in this case, we know some of the windfall sites. And they are identified in the topic paper, update, April 2024, on page 59 in table 8.5. So the plan knows about sites which we are confident will come forward, but we are not proposing to allocate because they are covered by supportive policies of land within urban areas, basically. So we have identified windfalls. Now that is counterintuitive to some people. The reason that we know about them is because we're not proposing to allocate them. They could have been allocated, but the council chose not to allocate them, but to rely on them as part of a windfall allowance in certain parts of the area.
If I may, on this one as well, just if I may as well, Ma'am, just in terms of, I think there's probably quite a lot of conversation today, probably about and over the course of this week about windfall as well. And so I'm not going to, I'll obviously wait, obviously for others to have a say as well, and we can respond as appropriate on that. Obviously, these are the evidence which we are proposing is in attempt to provide compelling evidence for a windfall allowance in certain settlements and in line with the framework's requirements of evidence required to justify windfall allowances. So this is our attempt to provide that compelling evidence to you and the examination on that point.
Thank you. So would it not have given more certainty, particularly to those landowners, in terms of allocating them and having sort of guidelines as to, you know, what would be required and how they should come forward, etc., and to everybody else, sort of some comfort that they're more likely to come forward?
Well, I think as Mr. Richards has said, that is an option, but clearly I think we have a rich tradition of windfall development in Shropshire. The overall, I think it is appropriate that councils, when compelling evidence is provided, are allowed to have a degree of windfall allowance. I think that's necessary in some respects to avoid sort of overdevelopment in areas as well. If you allocate right up to the housing requirement, it gives you little place to go, I will say, in that context. So I think that, and in terms of the compelling evidence and in terms of the overall amounts of windfall that this council is proposing to rely on to meet its annual housing or proposed housing requirement, we're talking just over 100 dwellings a year, which we think is cautious but reasonable.
Okay, just I've not looked in detail at those sites that you're saying will come forward as windfall. What are their existing uses at the moment? Are they?
It varies, Mom. So in identifying them, we've used various mechanisms, including the strategic land availability assessment. We've used our intelligence from our affordable housing enabling officers who deal with exception sites. We're aware of sites that are in the council's control as well. So we've used various sources to identify them, and obviously that means that the background of them, their existing uses vary. What I would say is obviously those are one example of types of windfall. What we've also looked at is past trends in terms of windfall, and also where we're at with settlement guidelines and windfall allowances. So using Shrewsbury as an example, for instance, at submission, we proposed a windfall allowance of 505 dwellings. At 31st of March 2023, that windfall allowance had already been exceeded by 81 dwellings. So we were in a situation where the plan was proposing to allow no further windfall development in Shrewsbury, obviously with flexibility to allow for that number to be exceeded subject to wider policy compliance. But there was a recognition there that in actuality, windfall development has come forward earlier than perhaps expected, but also at a greater rate. And given that we know of other windfall opportunities, some of which were granted planning permission after that base date, so a number of the sites in table 8.5 actually now have planning permission. Towards that was part of that compelling evidence that the windfall allowance that we had in the plan was very cautionary, and there was an opportunity to extend that in certain locations to accommodate the proposed uplift to the housing requirements.
One final question before we open it up to the floor, but in terms of residential windfalls, are they likely to result in a reduction in employment land use that then has a sort of knock-on effect that would be considered in the round if they were allocated sites?
All the sites in table 8.5 would not contradict or are considered consistent with policies in the draft plan. So we have policies that seek to protect existing employment. So none of the sites are considered to have tension with that approach. Clearly, there may be sites that seek to come forward as windfall on protected employment land, and we have a policy framework proposed in the draft plan that would allow us to process that and determine whether that's appropriate or not. In terms of our economic development needs assessment, one of the key considerations in that was the fact that there is inevitably churn, and part of the conclusions in terms of the amount of employment land that needed to be made available was to accommodate for that level of churn.
So if I may, Ma'am, and that's done, so open this up openly, but we haven't included some potential windfalls. We know of some opportunities, but there might be a tension there with policy, which would obviously be a consideration in the round at that point. So we haven't included some options within that because we don't think it's compelling because of that tension. But for example, we are in one at the moment, as the council is clearly moving out, and there will need to be a discussion about what happens to this old place. I'm not preempting anything about that. It's not included in our compelling evidence, but it's just to point out there is local knowledge and understanding about things that will happen and considerations we will need to do down the line. It's a planning judgment at that point.
Just by way of another example, the Caterpillar site in Shrewsbury, part of that site previously had planning permission for around 200 dwellings. That subsequently lapsed. It is protected employment land, so it's not identified as a potential windfall site, but clearly there were previously aspirations for residential in that location. But again, it's not identified as a potential source of windfall, but it may be that comes forward as a potential windfall site again in the future.
Thank you. That's helpful. That's cleared up some things in my mind and maybe somebody else, other people's as well. It's kind of covered some of the issues. So what I'll do, I'll open up now. And as I said before, we'll just deal with it in the round and go around person by person. And if I think there's some points that I think the council need to draw on, then I'll ask them to do that. So what I'll do, we'll start with Mr. Cook and work around this area, and then move to the back to Mr. Roberts and across. So say kind of everything you really want to say on this matter, and it won't be the end of it, you can come back or whatever, but if you cover all your points, and then we'll get the council to comment. It might, by the time we get to the last person, there's not a lot left to say, but
yes, thank you. 2 points from me really, and they are as set out in my statements. I won't drag the points out too long, but the first is about reasonable growth options in the SA and what's been tested and what hasn't. And reading the council's matter statement and hearing what's been said this morning, I think the point is taken in terms of it's ultimately down to the council's judgment as to what options and assessments they do make. But it's fairly apparent from the various ID documents that have been back and forth since the stage 1 sessions, and indeed representations to those sessions, that it seemed fairly obvious for the council to have assessed the 1,500 in addition to the 30,800, I believe it is, looking at my notes, as a reasonable option. It seems that it was an obvious option, and I think various people around the table have all made that point, including, like I said, in the ID documents from yourselves. So it's just curious as to why that hasn't been tested. And the second point for me is to do with the windfalls, matter of windfalls that have just been discussed. And again, not to go into it in loads and loads of detail, but it's just a question on how sure the council is in terms of relying on the windfalls. The NPPF, of course, requires compelling evidence in respect of windfalls, and our matter statement really raises concern in respect of figure 8.1 of document GC 45, which is the housing topic paper, and that is on page 41. And the point that we make simply is that if you look at the final column of figure 8.1, the proportion of total completions on windfall sites steadily decreases year on year from 2018-19 through to 2022-23. So that, notwithstanding the points the council have just made on windfalls, is that trend is rather alarming, essentially a 20% drop in 5 years. And if that trend were to continue due to things like B&G, which obviously is a new legislative requirement for sites, that could potentially have an impact on windfalls coming forward. So it's just really ensuring that the council is sure in respect of windfalls. Thank you.
Thank you. Do the council want to say anything specific on that, or it might be useful to cover the B&G points? I think that's been covered by a few people.
Yeah, I will just mention that about B&G. I think, obviously B&G relatively new. I think it's fair to say most councils still grappling with the implications of that, including ourselves. I understand the general point about maybe potential more land take on existing sites. Is that the point you're making? Effectively, on allocated sites, we might not be able to. I'm not quite clear about the point you're making, unfortunately.
Sorry, the B&G point is an example of something that might impact upon deliverability of windfalls. But so I wasn't specifically making it in terms of allocated sites. But you are right. B&G in the round is an uncertainty that we're all facing, not just Shropshire Council.
I'm still not totally clear about how B&G would impact on the deliverability of windfall sites. So
essentially, it creates an uncertainty for developments. Generally, the industry is facing uncertainty in terms of viability and various other elements of B&G. It impacts things like net density, it impacts overall deliverability. It's not. It wasn't. It was. I raise it as an example. But my main point is in figure 8.1 that there is a downward trend of windfall. I'm not attributing it to B&G. I don't know what the reason for that downfall is. Downtrend. I'm speculating, but perhaps that's wrong with me.
Yeah, just a couple of points. Firstly, with regards to table 8.1, obviously that illustrates the significant levels of windfall development that have arisen in Shropshire. There are various reasons for the trend, primarily related to larger scale sites. So in the earlier part of that 5-year period, there were large windfall sites that had come forward. Obviously, they reduced later on. I think what's probably useful to put that, though, is in some context. So the 5-year housing land supply, the windfall allowance that is included, and obviously this applies to the supply across the wider plan period, includes an allowance of 299 dwellings per annum on small windfall sites of less than 5 dwellings, and then an allowance for specifically identified windfall sites through the SLAR and affordable housing mechanisms. So it's an incredibly cautious approach in the supply. In terms of the achieving the requirement proposed in the draft plan, based on existing commitments and proposed allocations, the allowance is for 100 dwellings per annum on windfall sites, which the council considers is very cautious and robust. That is, as I say, that is effectively the difference between the commitments and allocations and the proposed requirement. It's just less than 1,500 dwellings over a period to 2038. And obviously the base date for that was 1st of April 2023. So over a 15-year period, the reliance on windfall to achieve the housing requirement is less than 1,500 dwellings. In terms of the BNG point, with regard to proposed allocations, I just emphasise the fact that the draft local plan included a policy requiring 10% BNG because we were foreshadowing, expecting the introduction of the Act. So that was given specific consideration when we were looking at capacity of site allocations and also viability of development. So those factors were considered in our viability assessment. What I would say is obviously in Shropshire, density of development is a lot lower than in more urban locations. We have policies that require quite extensive areas of open space based on the needs that we've identified, but also based on the characteristics of our settlements. So development is perhaps lower density than you would experience in more dense urban areas. What that means is the significant areas of the site where there are opportunities to incorporate BNG without reductions to the overall deliverability, dwellings delivered on the site. So, for instance, we require 30 square meters of open space per person, with an assumption it's one person per bedroom. And there's no expectation that wouldn't be capable of accommodating BNG. In fact, we would encourage it because it's an opportunity to get greater biodiversity and social and economic value from the open space provided on a site. So I don't agree that BNG would affect the levels of windfall development in Shropshire or the capacity of site allocations. My view is that the approach we've taken through site assessments and the characteristics of development in Shropshire would allow for that to be accommodated without significant impact on density of development.
Thank you. Is there anything else you want to say, Mr. Cook, before I move on?
No, thank you. Other than just to reiterate that I perhaps wish I raised BNG now because it wasn't central to the point, really. I was speculating as to the trend, and as Mr. Corden said, he's of the view that it's to do with large sites and delivery. So, no, I'll pass to various other people to my right and behind me who I'm sure have got other things to say. Thank you.
Thank you. Turn to Mr. Brogden.
Yes, Brogden. Yes. Just as well, but start off by just confirming that everything's been said today continues, or in my opinion, the shortcomings of the approach adopted. Sorry. Just everything's been said this morning so far sort of confirms, in my opinion, the shortfall really in the approach adopted. I think this effectively confirmed that no new sites have been looked at, which effectively is a continuation of the shortcomings that have been voiced by various parties to date. If I may just raise a further point, in the statement of common ground with the Black Country authorities, they've confirmed that the extent of the unmet need is not established. But on that basis, I'm not quite sure why the figure of 1,500 houses and 30 hectares is being adhered to. when it's not established. It's an arbitrary figure which is effectively appears to have been plucked out of the air and is now continued as a sort of de facto number that's assumed to be correct. That can't be right as a starting point, particularly when we move on to the conversation about windfall sites. If windfall sites exist, I don't think from the conversation this morning that they've been considered to meet the Black Country needs. It's purely a Shropshire County Council solution. But the Black Country needs are, if I say black and white, in terms of 1,500 houses and 30 hectares, it's a given. Surely windfall sites can and should be looked at in terms of the 1,500 houses and the 30 hectares. I'm also not clear, partly because it hasn't been said, whether windfall considerations apply to employment land or just housing land. But it to my mind, they should be. And then just following on from that, at the moment, there's a over provision of employment land proposed to meet the Black Country needs of the 30 hectares. And there's also safeguarded land. And again, coming back to the point about windfall sites, if windfall sites exist but are not identified, then there shouldn't be a need for safeguarded land because will be picked up by windfall sites. So there seems to be an element of two approaches being adopted, one to address the Shropshire numbers and one to address the Black Country numbers. And I'm not sure why the same approach isn't being adopted for both.
Thank you. So in terms of the number of 1,500, I think we've established in previous correspondence that ship sailed, if you like. So we've agreed that it was difficult to get a number. There is no number at the moment, and as I'm aware, those plans are still not at examination, and there are various numbers going around that are quite big. So I think we stick with what we've got in terms of 1,500 homes and 330 hectares, of employment land. I think we established that's the best we're going to get kind of in terms of that. So I don't want to start reopening that argument at this stage. In terms of the other points, I'll ask the council if they can pick up on some of those. So whether windfalls were considered to meet Black Country needs as well, and about this safeguarded land point as well.
Okay, I'll pick up the point about the windfalls for the Black Country need. The original submitted plan effectively took a position where the 1,500 proposed would effectively be met on non-specified locations on sites which were in accordance with the strategy. That was the proposal for the council. Subsequently, following stage one hearing sessions and in the context of ID 28 of the inspector's interim letter, there's a requirement through that process for us to, paragraph 21 of ID 28, there's a requirement on the council to identify sites to meet that need. So that's why we've undertaken the exercise to identify sites to do that in responding to the inspector's concerns in ID 28, paragraph 21. So in that context, our version of that is that windfall is not open to us to consider as part of that process, because that would be contrary to ID 28.
Principally for monitoring reasons.
Yeah. Well,
it's very difficult to monitor windfalls against a specific Black Country need. Much easier to monitor completions on identified sites.
Just indeed, and supporting the effectiveness of the plan, I think, is the phraseology around that. So that's the reason why we've done that. And obviously, but I appreciate there'll be some views in the room about that. The second point was safeguarded land. Did you want to pick that up, Dan? Sorry.
Yeah, the council recognises that there are some settlements where capacity for windfall is more constrained because of their characteristics, primarily because they're located in the green belt. And in order to ensure that there's a long-term sustainable strategy, when authorities review Greenbelt, there's a need to consider whether it's appropriate to identify safeguarded land to ensure that Greenbelt boundaries can persist beyond the period that the plan addresses. So the council feels that that requirement applies in the case of a number of settlements in Shropshire, specifically Shirehall, Albrighton and Alverley. And it is for that reason that we're proposing safeguarded land. What I would say is obviously safeguarded land is not an allocation, so it's not allocated for a specific use, and development of that land can only occur when it is allocated for a specific development within a future local plan review. So what safeguarded land is effectively doing is seeking to ensure that there are future growth options for settlements to ensure that we can meet future needs without identifying what those specific needs will be at this time. And it's because we've undertaken a Greenbelt review to support this local plan examination, and because of our recognition of the characteristics of those settlements that we are proposing that approach.
Thank you. Is there anything else you wanted to add, Mr. So, Mr. Wade.
Hi, thank you. I think the key kind of queries that we had around the plan and the sustainability assessment in particular were in relation to both the reasonable alternative options and the reasonable assessment geography. So on the reasonable alternatives, while we appreciate that the council can't assess every single scenario, we do think that every time the council have looked at the figure and it's been an increased figure, they've decided that's the most sustainable option. And I think while those haven't been substantially different, there could have been scope for a further increase to test whether that would be the most sustainable option. And that's been somewhat recognised by the council in their proposed amendment to draft policy SB2, which now refers to a minimum of 31,300 dwellings. And while we support that principle, we think it would be best to test that fully in the sustainability appraisal and allocate additional sites to meet that need, to provide the certainty and ensure that those are fully assessed in the sustainability appraisal rather than being delivered as windfalls as they're currently proposed. And then just the second point on the reasonable assessment geography. While the methodology may have found certain sites most suitable, it's not entirely clear in the updated sustainability assessment what the exact scope of that was, and it wasn't entirely clear that unallocated sites had been re-examined for that purpose, because it would appear that if you'd looked at the data had been looked at a more granular level, further sites would be found to the east of Shrewsbury rather than to the west. And that geography, if, say, for example, community hubs to the east had been looked at in further detail, might have turned out a different result effectively. Thank you.
So what you're saying is that you just turn your microphone off. So thank you. So what you're saying is, do you think there'd be additional sites that should have been assessed that haven't been assessed? Is it?
Based on the essay as published, yes, or reassessed at least to look at that specific need.
Okay, I'll ask the council to come back because you said you'd done that work.
Yeah, just in terms of the sites, just to confirm again, once the reasonable assessment geography was identified, we considered all sites that we'd identified through the process, not just proposed allocations. So all those sites were assessed. And I think if I just read one of the paragraphs from GC44, the additional essay, hopefully that sets it out clearly. So it says, for the avoidance of doubt, paragraph 12.71, got too excited there, obviously. For the avoidance of doubt, this additional work considered all sites within the relevant assessment geography that proceeded to stage 3 of the site assessment process, both within the Greenbelt and non-Greenbelt sites, and not just those sites that are proposed for allocation within the draft Shropshire local plan. This assessment also explicitly considered the outcome of the Greenbelt assessment and review undertaken to inform the preparation of the draft Shropshire local plan. It also specifically assesses the relationship of sites with the Black Country. So hopefully that gives a bit of context in terms of what we had assessed, and that's within the essay itself.
And that totals, I think the combination of that exercise led the council to reassess around 450 potential reasonable options for accommodating that. So we're a county blessed with lots of site options. 450 is, in our view, a very reasonable number for us to consider. So we don't agree with the premise of Mr. Wade's conclusion to that.
Mr. Wade, do you want to come back on any of that?
No, thank you.
Okay, thank you. Mr. Maxfield, do you want to go next, and then we'll probably take a break?
Thank you. So our main point is around the reasonable assessment geography. Adding somewhat to what Mr. Wade has said, we're concerned that the reasonable assessment methodology, reasonable geography that was assessed, there is some historic data about patterns of work and migration of populations between the Black Country and Shropshire, but that is data that relates to an unplanned situation. That is it's an observation of what has happened in the past. What we are now talking about is 3,000 people, 1,500 at least, coming from the Black Country, and there is nowhere in the sustainability appraisal that assesses the socioeconomic effects of relocating those people out of the Black Country. And while work patterns, travel to work patterns might be relevant from looking at the past, what we now have is a planned situation and deciding exactly where those relocated people from the Black Country would live. And it turns out that because the reasonable geographic areas were so large and broad, using sub-geographies within Shropshire, the place plan areas, you end up with the most inaccessible location in Shrewsbury and the most inaccessible location to the south of Telford being established as the most appropriate locations for establishing the unmet need. But clearly in your letter to the council, you suggested fairly strongly that those locations that may well be found for providing the unmet need of the Black Country would be towards the areas that are closest to the Black Country, which makes perfect sense from a planning perspective. It's not only we don't want to only look at past migration patterns, but there would presumably be some interaction between the new people living in Shropshire from the Black Country and their work already in the Black Country, their social connections in the Black Country. They're not only going to relocate in order to work in Shrewsbury or on the edge of Telford in Ironbridge. So it is a complete lack of the socioeconomic impacts of the reasonable geographic areas that is lacking, and I think it amounts to about 4 pages in the entire sustainability appraisal about where the areas of search should be, and that needs to be addressed. Things like skills, the demographic profile of people who are likely to relocate, and how that's going to change the demographic of Shropshire. It seems that actually what is intended is that Shropshire Council plans for people to relocate from the Black Country to these sites and have no connectivity anymore with the Black Country, and it's an attempt to Shropshirefy people from the Black Country and to attract people who can jump in a car, drive 40 minutes to the Black Country back to their work, rather than have an excellent, strong connection with the people that they've left behind, their work that they've left behind to relocate to Shropshire.
Thank you, Mr. Maxwell. Do you want to come back on any of those points, Mr. Wood?
Yeah, I do. Thank you, Mel. I think Mr. Maxwell's points. So I've noted Mr. Maxwell's points about the. In a nutshell, I think it's the adequacy of the assessment and the adequacy of the consideration of the geographic areas. Our position is very clear. We think we have undertaken a proportionate exercise in looking at adequate areas and suitable areas in accommodating that need. We feel as though we had that geographic proximity to some degree confirmed by ID 37, but obviously that's a point which maybe others want to make as well. Yes. Yeah. Okay. In terms of the wider points about seeking to Shropshirefy people, I've never heard that term before, Mr. Maxfield. Yeah, it's you can have that one. I don't think I'll use that one, but just a point really on this one. Shropshire is probably not a unique county in this respect, but its population growth is entirely based on migration trends. So when we look at our local housing need, that is effectively migrationary trends. What we're doing here through the agreement with our colleagues in the West Midlands is to effectively increase that migrationary trend, but it's just a wider point that those trends are happening. Whether we like it or not as planners, it's happening. Okay. So the basic point is we consider we have got a proportionate exercise. We feel as though that has resulted in the assessment of the reasonable options we consider. And I think some of the points here being made are veering on the concerns about the outcome of the proposal, or the outcome of the exercise, not the adequacy of the reasonable options being assessed. So, and I think obviously there's a point here to be made about the sustainability appraisal and what it's there to do, and that in that context. So just a few points there. I don't know if you've got any things you want to say.
Yeah, just one point to add. Obviously, when we identified the reasonable assessment geography, that was informed by specific consideration of proximity and transport links, migration patterns, commuting patterns and travel to work areas. When we then undertook the more detailed assessment of the sites that were in that assessment geography, we also specifically considered connectivity to the Black Country as part of that process as well. So within the reasonable assessment geography, when we assessed the 450 sites, one of the considerations was the linkages to the Black Country, and that informed our considerations and our decisions in terms of which sites were appropriate to accommodate the contributions proposed.
Thank you. Do you want to add anything, Mr. Maxfield? Okay. Which is dead at 11:30 now, so I suggest we take a short comfort break. Sorry. Yeah.
Apologise, David Manley representing Pottingale Homes. When we started on this side of the room, I thought we were originally responding to the answers given to your questions, but listening to Mr. Maxfield, he seems to be addressing your question one, in effect, of your formal agenda. And I just wanted to know, are we on to question one?
Yeah, I think what I said was we deal with 1 to 4 in the round, so we'll deal with the essay in the round.
Okay.
So as I come to each person,
you do your full
the
pitch.
4 people.
Got it.
Have you understood that or not?
I hadn't quite understood
That's
that.
fine.
That's me being dense. Don't worry about that. I've got the point now. Thank you.
So yeah, to save sort of time, because it goes back and forth a bit when you've got different questions, and by the end of it, you've kind of covered them all anyway. So I think it's easier just to talk in the round about the essay because different people have different issues with it, you know.
No, I'm grateful for that clarification.
Okay, thank you. So we'll have a break. There's quite a few people to use the facilities and things. So if we say 20 minutes, that gives everybody a chance to get a drink. And the council have provided water, and I think there are some vending machines.
For the sum of 50p. All donations welcome. You can get yourself a cup of coffee from the Clicks machine outside, or a cup of tea, in fact, or hot chocolate. But we haven't, unfortunately, got any other refreshments aside from free water. So.
Thank you. So if we come back at 10 to 12. Okay, thank you. Okay, so if everybody's back, we'll resume. We're up to you, Mr. Morrison, will we?
Yes, ma'am. Thank you. Thank you very much. Miller, I think I'll summarise the main point. I think if I made them wrong, which I understand from the clarification is now the way forward. So from our perspective, my client's perspective, Miller Homes, we effectively, where we see we've got to is we have a situation where the plans function, and one of the main functions of the plan, the bit that we have there's still some concerns with, is the need to accommodate the 1,500 homes in the most sustainable manner, and to kind of look at it from a sustainability perspective, which is where I come from. It's really to get those in the most sustainable locations so that the people who move there and want to commute and work in the Black Country can do so in the most sustainable manner. And for example, that would be through the use of trains or not necessarily the private car. Yet we seem to have ended up in a situation where there's been no new sites, but the sites that have been identified to meet that unmet need, one can argue, are they really in the most sustainable locations? In our reps, we identified, the Bridgenorth site as an example, which is a perfectly good site, very good indeed to meet the Shropshire's needs, and there's no problem with that whatsoever. But to commute to the Black Country from there has to be done by private car. And I suppose then we look backwards, and then we looked at the GC44 and the updated sustainability appraise, and particularly section 10, which is where we understood, is the assessment of the options to meet that unmet need. And it concludes in there that yes, option 1, which includes the windfall allowances, is the most sustainable option. So I suppose my first question is, and this is the most sustainable option when compared against the other options, which one of those being, let's have some new sites, or let's do early release of safeguarded land. And I suppose my question there is, how can you, one, determine the sustainability performance of an option, particularly that has windfall allowances, as indeed has been identified, you don't know where they are. You can't identify where those may be, and it might be, for argument's sake, those windfall allowances are not in the most sustainable locations. And then if you look at GC44 and some of the assessment, and I'm not going to get into pluses and minuses and scores because we could be here all day for that, and I fully appreciate it. But, just to highlight one particular thing which articulates my point, is that, for example, under option 3, where you have the ability, from a sustainability perspective, to control where those sites would go, because it's your choice about where you release the sites. It identifies that has potentially for a negative impact or an uncertain impact with regards to commuting, the use of private car. Yet it says option 1 has a positive impact with respect to commuting by private car, but yet you don't know where those sites are going to be. So I think effectively that probably sums up our concern with it, which is perhaps we feel we've ended up with not the most sustainable option to meet that unmet need. And if there was a reappraisal of it, and seeing where we'd ended up, one might make a different conclusion from that particular assessment, and then that might lead you into then taking a revision once more, looking at your individual sites to focus on where in fact is the best location to meet that unmet need. So I hope I've communicated that clearly.
Thank you. That's it's quite helpful. Do you want to come back on those points, particularly the anomaly as it's been identified?
Just to be very clear, because I think Mr. Morris has got the wrong end of one particular stick. So far as the 1,500 are concerned, Mr. West and Mr. Corden told you this morning that for the sites to meet Black Country needs, the 1,500, what they did was they identified the reasonable assessment geography, as it's been called. Then they reassessed all of the known sites, the 450. And then 4 sites were identified. So the process that Mr. Morris was contending for was in fact carried out. Mr. Corden in a moment will tell us whether or not the Miller Homes sites at Shifnal were part of those sites considered. Once the Black Country's 1500 had been put to bed, then the council looked at the 4 options for meeting the additional Shropshire need, the 500 uplift. And that's when windfalls, densification, extend new allocations, or a combination came into play. That wasn't the process for looking at the 1500. That was for the process of looking at the 500. Now, Mr. Corden, who's a master of the detail, will tell us whether or not the Miller Home sites were included in the first part of the process. But otherwise, the difference is one of judgment, not about whether or not alternatives were assessed.
Yeah, just to confirm, the sites at Shifnal were considered in the context of potential sites to accommodate the proposed contributions to Black Country. They're specifically within Appendix 8 of GC44. So yeah, just to reiterate the points that Mr. Richards has made, Section 10 of GC44 specifically looks at the various mechanisms for accommodating the uplift to the housing requirement. Chapter 12 and the appendices to the essay look at the options to accommodate the 1,530 hectare contributions to the Black Country. They're dealt with as 2 separate issues and clearly summarised within the document to provide clarity on that approach.
Do you want to come back on that, Mr. Morrison? Oh.
No, thank you, Mum. That's fine.
Just a quick question that's arisen in my mind. So the 450 that you assessed and you found 4 that were suitable, how many of those 450 were sites that are already in the plan as well?
I don't know the figure off the top of my head, but every site within that assessment geography will be considered whether it was a proposed allocation or not. So every proposed allocation within the areas that we identified, so the central and eastern parts of Shropshire, alongside every other site that wasn't proposed as an allocation, was assessed. So effectively every site that's proposed for allocation in that geography was considered.
Thank you.
Is it worth saying that the appendices to GC45 1 through 1 through 9 and then to 10 as well identify those settlements which were in remit for an assessment. So they are Albrighton, Bridge North, Broseley, Highley, Much Wenlock, Shifnal, Shrewsbury, as well as the potential strategic locations and strategic settlements. So anywhere where there was a potential new settlement as well was included in that assessment as well. So just to confirm.
Thank you. Return to Mr. Handy now.
Thank you, Mom. You'll probably be happy to know that most of the points we would have wanted to have covered have been discussed already this morning. It's a bit of a small flag. We probably have continued concerns about some of the windfall allowances and in particular how they relate to certain settlements, but clearly that's for later on in the examination programme. So with that in mind, I'll probably pass on.
Thank you. Mr. Thomas.
Thank you, Mum. Just for clarity, I'm here acting on behalf of CEG, who have a controlling interest in site allocation SHR 158, which is obviously part of the strategic site allocation and one of the sites selected by the council to accommodate the Black Country housing need. I've got 2 brief and hopefully reasonably simple points to make, if I may, Mum. The first is that we are unclear as to why the council has selected Shrewsbury as a reasonable option to accommodate that need, which I'll come to in a moment. And the second point that's aligned with that is if and it's a kind of big if in our mind, if Shrewsbury is considered appropriate, we're really unsure on the quantum of apportionment to our particular site allocation. And second point within that is why our site has been selected over others within the county town of Shrewsbury. So if I just come back to the
the first point is to, we're really unclear and uncertain as to why Shrewsbury's been selected. If you look at the 7 settlements that the council have chosen, which are all Brighton, Bridgnorth, Broseley, Highley, Much Wenlock, Shifnal and Shrewsbury, geographically Shrewsbury is really the anomaly to that. All of those settlements are in the east of the county, and Shrewsbury clearly is central to that. It's interesting in our mind that the council have selected Shifnal in particular as a site to accommodate for employment need, but seems to then ignore it or housing. We're not really clear on that particular point, and there are other settlements in that list that do have site allocations against them. The council have kind of ruled out. What we can kind of see and establish from the council's evidence is the council seem to predominantly rely upon the Shrewsbury to kind of Wolverhampton railway line to justify that inclusion. We just seek some clarification and question on that. As our understanding, the quickest, frequently travel that route myself, and I'm sure many in the room do. The quickest travel time between Shrewsbury and Wolverhampton is around 45 minutes. It's approximately 35 miles, and we're just not sure how accommodating the proposed contribution to Black Country on a site in Shrewsbury would contribute to the achievement of the wider spatial strategy for Shropshire. So that's kind of the first point, if I may. And then the second point to that is that if we arrive at a point through the examination that ultimately Shrewsbury is appropriate location, then we're just really not clear on the assessment that the council have undertaken in the sustainability appraisal. Because if you look at table 12.4 of the updated SA, our site, which is, as I say, part of a strategic site allocation, including 158, 161 and 060, is only assessed by the council as being fair in respect of Black Country sustainability. Alternatively, there are other sites in Shrewsbury, 057 and 177, both of which that score good. So we're really just not clear as to how the council have gone through that kind of process to arrive at our site. I take the point, obviously, that there's a kind of balanced planning judgment to be exercised, as articulated by Mr. West, but we're just not really sure of the process and methodology and conclusions that arrived to that point, particularly when our site seems to be scored by the council as only fair rather than good. And then final point, if I may, Mum, is that just a point about the apportionment, really. The figure 12.4 of the council's assessment basically states that only 11.9 of commuters to the Black Country currently travel from the Shrewsbury Place Plan area as a whole. Our apportionment is 20% of the overall figure. And ultimately, in our mind, that would effectively have the effect of increasing the average distance travelled by Shropshire commuters to the Black Country. And made the point, we feel that sites, particularly further to the east of the county, Much Wenlock, Shifnal, would have been much better placed to accommodate that need.
Thank you. Just a quick question before I move to the council. Just so I understand, what's the concern that it's part of the sites now been allocated to the Black Country need rather than just Shropshire? Is it to do with deliverability or?
No, I think it's a point of simplicity. Ultimately, my client is looking to obtain a planning consent at some point in the future, and we are concerned around that apportionment, that it doesn't provide some simplicity to the site allocation, and provides an unnecessary layer of complexity to that site allocation. And I'll come on, I'm sure, in future sessions to talk about our concerns around the changes to the site allocation description and guidelines that articulate that concern. It's not, it's no more than that, if I may say. It's a point about simplicity, and ultimately, at the end of the day, trying to get a planning consent at the end of this to deliver housing, and we're not sure why. And we've had a great dialogue with the council, as you'd expect, in terms of the site allocation, but we're really still unclear why our site's been selected for the reasons I've articulated.
Thank you. I'll ask the council to address that point.
Thank you, Mum. Thank you, Mr. Thomas, for that. Just to reiterate, we are in very good conversations with Mr. Thomas and his clients around that site, but obviously this is a point where we don't agree on. The point which you raised, Ma'am, and the question raised is quite a good one in our eyes about effectively what's the difference. There is no difference in our eyes. We talk about simplicity. We purely, and this is a fairly obvious point, but it's worth making just in case anyone was under any concern. There's no restriction of use proposed in any of these policies for they have to be from people originating in the West Midlands, Black Country area. There's nothing to that. We are not envisaging a planning application with such a restriction on. Rather an odd thing to do. So we're not doing that. This was really as a point of partly, as I said, responding to the concerns you'd raised, and we, in our view, that concern was about effectiveness of effectiveness of monitoring, in fact, in making sure that need had been met, that unmet need, which we were accepting, had been met on a suitably located proposal. In terms of the actual assessment, I think we just need to make a wider point here about the difference between migration and commuting. Here, we are proposing that the Mr. Thomas's site is capable of accommodating up to 300 of the 1,500 out of the 1,500 development guideline for the site. As I said, that doesn't, from our eyes, doesn't make a difference in terms of the actual delivery of the site. There's no implications on infrastructure, anything like that at all. So when and the point I made early on is a useful one to reiterate as well. Shropshire is reliant on migration. Shropshire gets migration everywhere. We don't have just migration from the West Midlands. We have migration from a great number of areas. That is what we rely on for our population growth, effectively. That's what our research and information. It's not a particularly, it's quite a challenging position actually as a council to make, but that is where we are at. So, and the point about the difference between migration and commuting, because I think it was Mr. Maxfield made the point early on about, yes, there will be this continued relationship between people who had migrated from a certain area, but we're not talking about a commuting kind of relationship here. We are talking about individuals coming and living in Shropshire. I suppose it is Shropshire fine to some, I suppose, point. I don't think that's a particularly bad thing. But that is why there is a distinction between the proposals we're making for the housing and employment and where we would meet the employment purposes. And I know that hasn't been raised yet, but it's worth saying now. Obviously, we are proposing that the employment part of the unmet requirement is met in Shifnal. Because we do recognise there is a commuting issue there. There will be people commuting in and back again, which is why that was a big factor in proposing that site. The rest is more around migration on that one. So just want to make there's quite a clear distinction there, and I think I don't know if you want to make any.
Yeah, just to clarify a few points in terms of why Shrewsbury was selected. We've already talked about the methodology we utilised to identify the assessment geography, so I won't labour that point. Other than to say, obviously, when we undertook the stage 3 site assessment, it gave specific consideration to connectivity to the Black Country. That was one of the factors we considered when we identified preferred sites to accommodate the contribution. Stage 2A of the site assessment that Mr. Thomas alluded to, where we effectively give a site a good, fair, poor rating against the SA objectives. That is an important consideration in the site assessment process, but we very much recognise that the SA objectives, whilst very important, can in some ways be limiting because they don't cover everything, and there is a need for that planning judgment exercise to be laid on top. And in fact, that's specifically recognised. So stage 3 considers the results of stage 2A, which is the assessment against the objectives, but then considers other planning considerations, for instance, Greenbelt, which isn't considered in the SA objectives. And the SA Environmental Assessment Report, SD006.01, at para 1.6 specifically recognises that issue, and it says, note, sites with a poor SA rating may be proposed for allocation if the council feels that on balance, other planning issues outweigh the SA scores for that site. So there's a recognition that there is value to stage 2A of the site assessment process, but equally the process has to consider wider issues because that's how effectively a planning judgment is formed. And just to echo the points Mr. West made about housing, the difference between the proposed housing contribution and the employment contribution. In effect, the housing contribution is allowing people to migrate into Shropshire and then become part of our labour supply. So they would then take up occupation at jobs in Shropshire, use our services facilities. Obviously, we can't force them to live and work and use our facilities, but it's providing the opportunity to do so. With regards to the employment contribution, the expectation is that residents of the Black Country will commute into Shropshire to have their employment needs met, but they would then commute back to the Black Country for their residency, for their service and facilities, etc. And that is one of the reasons that we have taken the approach we have done in the site assessment, why we consider it's appropriate for the employment contribution to be met in Shifnal, due to its increased proximity to the Black Country, and due to the locations we consider appropriate for housing contributions to be occupied. So yeah, hopefully that's a helpful clarification.
Thank you. Presumably there'll be sort of some crossover as well.
I think inevitably we can't force people to work, and in fact we obviously already have commuting patterns. That was one of the factors that we've considered in informing the reasonable assessment geography. But the expectation is that the 1,500 contribution would to housing would also be an employment contribution as well. And the employment contribution of 30 hectares is in addition. So we're helping the Black Country with their unmet employment needs, both through a specific contribution to their employment contribution, a specific contribution to their unmet needs, and also as part of the housing contribution, whereby there are opportunities for those people that migrate into Shropshire to also work in Shropshire.
The intention isn't that the two will marry up exactly. That's.
No, we're not saying that
everybody that works on that.
Exactly. It's not like a co-location where we're saying 1,500 houses, 30 hectares of employment, those people live and work. That's not realistic. What we're saying is 1,500 houses with opportunities for employment in Shropshire, 30 hectares of employment for people commuting from the Black Country.
Thank you. That's helpful. I'll come back to you once we've been around the table. Otherwise, it gets, unless is it a particularly nuanced point related?
No, yeah, it's a very related point. If I may, ma'am. So is the council saying that the social infrastructure and employment profile of the Black Country is so similar to the social infrastructure requirement and employment profile in Shropshire that there can just be a simple crossover, and the skills that are available in Black Country can be relocated anywhere within Shropshire? And I think the council needs to come back on that point, because it's a related point to what Mr. Thomas is saying about the allocation of specific allocation to a specific site in Shrewsbury. Does that site have to plan for a particular need that is specific to a different geographic location? And the sustainability appraisal does not assess any of the socioeconomic effects in coming up with a geographic area.
Do you want to come back on that? That sounds quite a detailed sort of level of assessment.
It is. If I've understood you correctly, Mr. Maxfield, I think the proportionate evidence is a great phrase in planning, and I think we've produced a proportionate evidence base for this need. I think, and I will point out the SA objectives do talk about social and economic factors. Yes, they focus on environmental factors, but there are social and economic factors within that. So there has been a degree of assessment on social and economic factors, but I think I'm slightly unclear about what you expect the council to do here, and I don't know whether Ma'am, if you have got a view on that.
Yeah, I think we'll probably move. I think we've heard what everybody's got to say. And I think we'll move on. Mr. Cooper.
Well, I don't want to preempt what I might say in other sessions, but it seems to me that this sustainability appraisal is quite a blunt process, really. It treats the Black Country as if it's some kind of an amorphous mass, and it then, it's acknowledged that there's quite a broad area of Shropshire which is then considered to be suitable for providing a contribution to the Black Country's unmet needs in the future. Given that imprecise nature, I'm not quite clear why we've ended up with that requirement, just on 3 sites and at the size they are. Could we perhaps have an explanation as to why that approach was chosen?
Thank you. I'll ask the council to explain that for you.
So I think the question is why have we chosen 3 sites rather than many? Yeah. Okay. Well, it comes down to a point of planning judgment, and actually identifying sites which we feel that can accommodate that need in a sufficient way. It's nothing more more explained than that. I think the point you made about the SA being a blunt instrument, I wouldn't put it in that category, but I do accept that there is that's why you layer on professional judgment and planning judgment outside the SA process. It's necessary to do that. So I don't think we've got anything further to add on that, Marm. Sorry.
Thank you. That's helpful. Move on to Mr. Charles.
Thank you, Marm. Mr. Reid, who you heard from at length at stage 1, unfortunately isn't able to join us today, and also Mr. Rouse is unavailable today as well, so I'm afraid you're stuck with me. I'm Sebastian Charles. I'm a solicitor at Aardvark Planning Law. I'm also a legal associate of the RTPI, so I'm going to talk about both law and planning, if that's okay. I also have the advantage of having been involved since 2019, so I hope that my comments are going to be helpful in the round. We're not here today to talk about emission sites, but some of my points I will make by reference to examples that relate to my client's site, which is J3. It's in a sort of class of 1 in that it was the only strategic site consulted upon at the beginning of the process, but that wasn't carried forward into the plan, and it was ruled out for being carried forward into the plan at the 20th of July 2020 Cabinet meeting on the basis that it wasn't needed. My client is interested in both residential and employment land needs, which makes it slightly different from some of the other participants. And the points I'm going to make are primarily focused on reasonable alternatives. Today, I'm speaking about them as legal points, compliance points, but they are, of course, also points that go to soundness, and I'm not planning to repeat them all in the context of soundness on another day. But the thrust of our case is that there's been a total failure to properly consider reasonable alternatives. The 4 alternatives that were considered were windfall, densification, new sites, or a mix. And our concern is about the consideration of the 3rd option of new sites, in that we say that should have been undertaken in a much more sophisticated way and should have considered specifically the potential of known potential candidate new sites, not on a generic basis, which is how the council ruled out the 450 sites that it says it has. It should have specifically considered the benefits of co-location of employment and housing, because that's a key sustainability issue, and it should have looked at specifically the potential of sites to meet Black Country needs in a sustainable way. And it was only by excluding that level of sophistication from their analysis was the council able to conclude that the first option of increasing the windfall allowance was the correct option, but the consideration of alternatives was clearly fatally flawed. our submission is that increasing the windfall allowance is unlawful because you can't change something that wasn't found to be unsound before. Nowhere at stage 1 was anyone saying there's a problem with your windfall allowances, they're not high enough. You, madam, didn't direct the council to look specifically at their windfall allowance because nobody is saying that there was a problem with it. It has only been changed by the council because they didn't like the outcome and they couldn't find any other way of meeting the now identified need without allocating new sites. And we say the council had a predetermined view that it didn't want to allocate any more sites. And that's kind of been its objective to this whole process. And I think, madam, you're with us in identifying whether it's possible to adopt that position. There are a number of problems with windfall sites coming forward, some of which you've identified already, madam. One, the key point that is unique to us because we're concerned with both employment and residential land supply is that if those windfall sites are going to be employment sites that come forward as residential, you're robbing Peter to pay Paul, and as you deliver residential, you're going to create a shortage in employment. I haven't got all of the information about table 8.5, but I just had a quick look. There's a former creamery, that's one of the larger sites. There's something called Vicam Works. Clearly there are employment sites that are going to come out of that use. And we say, as I say, you're robbing Peter to pay Paul. Other people will make lots of points, I'm sure, about how likely they are to come forward, whether they're sustainable, the absence of the ability to co-locate employment and residential, and other people have also identified how they're going to meet Black Country needs. Really, the main problem with all of this is that the council has failed to have regard to its pre-existing corridor strategy. And so I just want to flag up this document, ma'am, which hopefully you've got a copy of. It's attached to the back of our submissions here. And this is the 2019 Strategic Development Corridor Vision and Strategy. It's a Shropshire document. We didn't write this. I've got a spare copy if you don't have it to hand, but we say this is a very important document for considering how you meet Black Country needs. That's the Black Country, that's us, that's Shrewsbury. What we did, having read this, was then to conduct a Greenbelt assessment, a market assessment, an economic needs assessment, and then that led to the production of the Western Scheme and the master plan to meet all of those requirements. The council hasn't done that process in its sieving exercise when it looked at 450 sites, and we say that's, you know, a gross error, because clearly you should have gone back and at least looked at the strategic site that you'd considered before. And if you'd been more sophisticated in your approach to alternatives, you might have come to a different conclusion. But it seems this strategic site that was considered ruled out due to an absence of need hasn't been properly reconsidered as an alternative. And in our submission, it clearly is a reasonable alternative, and the council had all the information available at its fingertips to put it into the process. But by excluding it even from the process, that's how they came to the conclusion that the windfall allowance was the correct solution. Ma'am, there's nowhere in this document does it say the way to solve the strategic growth issue is to increase your windfall allowance, and that's kind of obvious. To give an example of the flaws in the council's reassessment of the 450 sites, in assessing Greenbelt impact, it assumes that all sites are wall-to-wall development and result in a total loss of Greenbelt within their site boundaries. That may be true for lots of other sites, employment sites in Shifnal and elsewhere. But ma'am, when you're looking at a strategic site like this, it includes within the proposal 500 hectares of green space and green infrastructure. So when assessing your Greenbelt impact, you don't assume a total loss wall to wall. This is making a significant contribution within its development proposals to Greenbelt purposes. And if the council had looked at it as an alternative properly, that benefit of the strategic approach would have become immediately apparent. That's just one example of a flaw. As I say, all of the other issues around co-location and everything else could have been taken into account. If I can just quote from this, A combined approach yields the best results, both locally, regionally and nationally, for economic, social and environmental well-being. In this document, it concluded that a corridor with strategic sites wasn't only an alternative, but it was the best alternative. And somewhere between 2019, when this was when the council's strategic corridor strategy was written, and the reassessment that it did to inform this local plan and how to meet Black Country needs, it seems to have forgotten all of that, because nowhere has it been reconsidered. The corridor strategy isn't mentioned in the council's analysis anywhere. No response, not dealt with. So we say there is a fatal failure to consider one very important alternative, and clearly the strategic site that was ruled out at the strategic site stage is a reasonable alternative that should have gone back in for detailed consideration, particularly given all the issues we've got to about Black Country need. You've had our point about the fact that it's unlawful to deallocate Shropshire sites in order to allocate them as Black Country need sites. I think you've grasped that point, Ma'am. I don't need to go through all of that again, but the point is if you're only fishing in sites already allocated to meet Shropshire needs in your target for meeting Black Country needs, there's a great danger that you're going to meet a great site or sites for meeting Black Country needs specifically in a sustainable way. And we say the council should have left the Shropshire sites alone and conducted a separate standalone exercise with a clean sheet of paper. What is the alternative? What is the best and most sustainable way of meeting Black Country needs? And at least the strategic site that had already been consulted upon should at least have been in the process and considered, rather than swept out with all the other sites. That's the main thrust of my points. I've got a few minor points to make alongside it, as you have asked to deal with all of the matter 2 questions. Our further point is that we've seen the restated statement of common ground this morning. We maintain the position that the provision to meet Black Country needs should be a starting point and a minimum, and there hasn't been any analysis of the potential and possibility of meeting a greater level of Black Country need in a sustainable way, which we thought you had specifically directed the council to do, but they have not undertaken that exercise. And also the statement of common ground about geography, we think is a little bit misleading. The Black Country authorities may agree that the locations selected are appropriate, but they're not ruling out that there might have been reasonable alternatives to those geographic approaches that might have been preferable or more sustainable. If you review the Black Country authorities' responses at the strategic site stage, including about my client's site, the support is emphatic for J3 as a location to meet Black Country needs, for co-location of employment and residential because of its sustainability credentials, not just the accessibility off the motorway and from the railway station, but it was fully supported at that stage. And I don't think the statement of common ground goes back on any of that. So I think that's important. One of your questions is, what has the council done to address our concerns? The answer is nothing. You've seen our pre-action protocol. The council has pressed on regardless. There's still no reference or explanation as to why the council stepped away from its strategic corridor policy. The council just seems entirely focused on not allocating any new sites in spite of all of the evidence in front of it. And we say that their process is bogus, designed to rule out what we consider to be an inevitable conclusion. You've asked a question about wider strategic environmental assessment, which we think is about taking into account wider plans and policies. This comes back to the West Midlands Combined Authority Economic Strategy and the WEMSIS document, which has been added to the inquiry room, the inquiry library. All of this is pointing to the need to provide greater than the minimum agreed level of provision to meet Black Country needs, because the big picture is that more development is going to be needed. And it all feeds back to the corridor strategy that the council seems to have completely forgotten about. I don't know if you want me to comment on plan period at this point in time. You've got Mr. Rouse's submissions, and I don't really want to talk about
Yeah, we'll
those.
deal with that later in the day, unless it might get covered as the day goes on. But,
Fine. And then just my final point was, Ma'am, you talked about MPPF amendments. It wasn't actually my suggestion that those needed to be taken into account now, but there is a school of thought that this plan should just be waved through as is, because there's an inevitability that there's going to be an immediate review to deal with an uplift in numbers immediately following on. And our view on that is, Ma'am, the trouble is nobody knows what an immediate review means. It might take 5 years, it might take 10 years. It's taken us 5 years to get to this point, I know, because I've sat through it all. We don't really want to wait for an immediate review. Let's grapple with the issues now. We think it's all pretty clear. The process involved in putting a previously consulted upon strategic site back into the plan and to review that decision from the July 2020 Cabinet report, we don't think is beyond your powers and the people in the room. I'm not specifically ruling out other sites coming forward as well. I'm certainly not attacking any other colleagues in the room, but we think we're in a class of one that merits specific consideration under alternatives, under soundness.
thank you. Do you want me to come back on those?
Yes, we do. I think we'll probably do a bit of a tag team on this one. So, Mr. Richards.
Yeah, just to deal with the two legal submissions that were made first. The first was that our approach to windfall allowances had not been found, quote, unsound, unquote, by you, and therefore we were not being directed by you to re-look at windfall allowances, and therefore that's unlawful. That was the first submission I summarise. Firstly, we were doing further work, as you described it in ID 28, and as a result of that further work, we reconsidered windfalls. Secondly, nothing has yet been found sound or unsound by you. You won't reach your final conclusions on the soundness of anything until your final report. You are directing further work. You are suggesting main modifications for consultation as we suggest them to you. But nothing is being found, quote, sound or unsound at this stage. Indeed, there is nothing to stop people in the room, and they have done it, from making or from continuing to make submissions that what you may have reached an interim view on in ID 28 or ID 36 or ID 37 is not sound. So that's the first point. It's the objection, the legal submission is predicated on a fundamental misconception that there have already been findings of soundness. The second legal submission was that it is unlawful to deallocate Shropshire sites to meet Black Country needs. That's not what the council is doing. Under the submitted plan, Black Country needs were being met everywhere. The Black Country needs were subsumed into the plan's numbers. As a response to a request for further work by you, we have identified sites which will be monitored as part of the process of ensuring that Black Country need is met. And we have not plucked the sites out of thin air. We have gone through the process that Mr. West and Mr. Corden has explained to you already. So again, that submission of deallocating Shropshire sites is based on a fundamental misconception as well. Thank you. Now, for the planning merits and the explanation of the process, over to Mr. West and Mr. Corden as usual.
I'll go first. Thank you. I just picking up on some of the points you referenced there, Mr. Charles. Just in terms of the point you've raised about the M54 corridor study. Sorry? Strategy. I do apologise, Mr. Charles. That's specifically referenced within our strategic considerations in the updated sustainability appraisal, where, and I wasn't clear about this point. I wasn't quite clear by the end of it whether you were suggesting we hadn't reassessed your client's site at all, or just not or the end result is wrong. I think it's the former, because you kept on saying it's been swept away. Well, sorry, I'm sorry.
Both. It's dealt with in the generic assessment, but our submission is it needed more sophisticated analysis.
Well, our response is it's not a generic assessment. It is your client site was included in the reassessment of site options to accommodate the BC need, Black Country need, and it's included in the updated and additional essay material. So I just want to make clear, so there's no lack of clarity in this room. The site was part of the reassess process, part of the 450. I granted we're probably not going to come to agreement about the satisfaction of the end results, but it was assessed. So, just whilst Mr. Corden just does that, I just want to make one point. Sorry, it was a couple of points. Sorry, it was a latter. One of the things you mentioned before about the site was your client's site was consulted on in an earlier iteration at Reg 18. I just need to make clear that that was not consulted on in the context of the client site being a preferred option. And it is very clear within that document, which we can find the reference for you, Mum. It's one of the strategic sites. Reg 18. EV, here is a 6.1, so 6.1. So that's the strategic sites consultation, and that took place in and that consultation started on the 1st of July 2019. You'll find from looking at that his client site, Mr. Charles's client site, was not included in there as a preferred option. It was consulted on as a potential option. Okay. So there is a difference between the two. Just the final point I just wanted to raise was about the West Midlands employment strategic sites piece of evidence, which Mr. Charles and I think at least one other representative has suggested should be included, and is now a note on the examination library web pages. I've read the submissions from Mr. Charles. There appears to be some not too well hidden accusation that we've been hiding evidence, and we dispute that entirely. That evidence was published about 6 weeks ago. In advance of that, it was only in draft and confidential, not for sharing. So and I know that because I was part of the scrutiny. I was part of the group who was involved in the commissioning and managing of that contract. In terms of the outcomes of that report, I'm not going to go into the details. Probably here's not the time to do that. It may raise its head elsewhere. But I just want to point out that in terms of the outcomes of that report, they are intended to support plan making, not to advise plan making. And the opportunity, there's a whole range of opportunity areas in the West Midlands that are proposed quite reasonably, and sites on the east side of Shropshire along the corridor are proposed as an opportunity area. We are not in argument with that. It is clear that there's an opportunity area there. This is why we support it and part of that piece of evidence. We will come on to other things later on, I'm sure, as part of the site assessment hearing statements, but clearly we are proposing employment proposals in Shifnal as well, not too very far away from Mr. Charles's client site, which we believe will address both a local and strategic need, and indeed that is recognised within the West Midlands Strategic Employment Sites report as well. But I'm sure we'll get onto that at some point later on. So those were just the points I wanted to make, just a few points of clarity from Mr. Charles.
I'll just pick up a few of the sort of minor points that Mr. Charles raised. Sorry, I won't say minor points, but the more peripheral issues, shall we say. In terms of the point about the potential that windfall effectively impacts on the strategy for employment, as we've already discussed, the EDNA allowed for churn within the supply, so that's recognised within our assessment. With regard to the specific site that Mr. Charles referenced in table 8.5 of the housing and employment topic paper, I believe it's the former creamery on Wharf Road at Ellesmere that you were referencing. That site has been in the majority redeveloped. The land we're talking about is the last few pieces, if you like, that weren't part of the redevelopment. So there is no active creamery on the site. It is housing in the majority. There is a couple of parcels of brownfield land associated with the site that were part of the wider planning permission originally granted, but haven't been redeveloped. And that wider planning permission was outlined, so it's now lapsed. But we do know that there are interests in bringing that land forward for development. It's a site, a brownfield site within the existing built form of Ellesmere, but it is not an active creamery, so it's not an employment site. In terms of the Greenbelt assessment and review, I think it's important to remember what the purpose of those assessments was. So the Greenbelt assessment looks at the performance of parcels against the Greenbelt purposes. It's a factual assessment of performance against purposes. It doesn't consider, other than whether it's for housing or employment, end uses. It is just purely what is the performance of those parcels against those purposes. The review looks at the harm that would result from the release of parcels. Again, it is not in the context of specific needs other than housing and employment. So those could be for housing for Shropshire or the Black Country, it could be for employment for Shropshire or the Black Country. It's a factual assessment of what would be the harm if it was released for that purpose. Mr. Charles suggested that because it looks at parcels, it doesn't assess if only part of the site comes forward, part of the parcel comes forward. I think there's a recognition that a Greenbelt assessment and review, because of the geography that it looks at, has to set reasonable parcels within which to conduct assessments. When those parcels are identified, the consultants considered characteristics to ensure that the parcel was effectively of a similar characteristic and had defined boundaries as far as possible to segment it up. But when they undertook the Greenbelt review, they specifically looked at whether there were opportunities for sub-parcels to be identified within the wider parcels that would have had lower harm if they were to be released from the Greenbelt. This includes parcels that over Junction 3, and the consultants did not identify sub-parcels within that location where they felt there would be lower harm if a sub-parcel was released. So that's how the assessment was undertaken. So hopefully that provides some clarity on that issue.
Thank you. Do you want to come back on any of those points, Mr.
I think I
Charles?
probably do need to come back on some of those points, Ma'am. Just first of all, there's no accusation of hiding evidence, but as Mr. West has confirmed, they had the study 6 weeks before it was published, and so the council was in a position to take it into account in their thinking. It's just nobody else was until it was published later, but there's no accusation of hiding anything. As regards table 8.5, you asked the question, does the council have the data about what the current uses of those sites are? The council doesn't have that data. I was only giving 2 examples. If you want to know the answer, I'm very happy to set Mr. Rouse on it and he will tell you exactly how much of it is currently in employment. But I do think that's a point the council could usefully deal with as it's their case, but we'll deal with it if you don't want us to. Can I direct you to Mr. Rouse's written submissions about monitoring? We're not proposing to attend that session, but he explains the problems with the council's intention to monitor the meeting of Black Country needs. Basically, it's impossible. There is something in Mr. Richards' point about we're not at the end of the plan and therefore you can't take legal points midway through the process. That is the gist of the government's legal service department's response on behalf of the Secretary of State to our challenge. We had intended to challenge the plan and stop it before we got to this stage because we thought it was so defective. We've been told to wait until you get to the end and see whether you still feel the same. So we're on hold. We're not going to be criticised for not bringing the challenge sooner. We've got to bring it at the end. But you've got our, various points about what we say. I think the gist of Mr. Richards's points is that this is all down to the judgment of the council as to what the reasonable alternatives are. But our case is just that the consideration of alternatives is so defective, even if the bar for reasonable alternatives is not that high, the glaring omission of failing to look again at a strategic site and to just deal with it in a generic way, I think is potentially catastrophic given the magnitude of the issues that we're talking about. The J3 site is £603 million economic boost into Shropshire, 9,100 economic jobs, interest from universities in the Black Country, all of those sorts of things. They're just too big and too important to sweep out on a generic review with all the defects I've identified. Mr. Corden has talked about their Greenbelt assessment. It did not take into account 500 hectares of provision within that strategic site. It just didn't happen. So we think the bar for reasonable alternatives has not been met by Country Mile. And I just want to come back to the corridor strategy. There is no analysis of the benefits of sticking with, there is no explanation of the reasons for ditching the corridor strategy in favour of increasing the windfall allowance. And the reason why there's no analysis of that is it would not produce the answer the council wants.
You want to come back on any of those points?
Thanks, Mum. Sorry, on your very last point, Mr. Charles. Sorry, I'm not quite sure I understand it. So you've mentioned windfall in the context of the M54 corridor strategy. Can you just repeat your point? So I'm just not understanding.
So
saying, sorry.
In considering your reasonable alternatives, you looked at 3 options: windfall, densification, and new allocations.
Okay, can I just stop you right there? Sorry, apologies. That was to accommodate uplift to Shropshire's housing need. This is not in the context of that's not in the context of reasonable options for accommodating Black Country need.
No, you've dealt with it all as a big pool.
No, that's not what we've done, Mr. Jost. We have assessed windfall. We've assessed a range of options for accommodating the proposed uplift to the housing requirement, the 500 houses that we are proposing to uplift for Shropshire's needs. We have assessed a range of options for how we could do that. Allocations is one of those. Windfalls is one. identification is one. Now that's for Shropshire's needs. We've also, as a separate part and a separate exercise in responding to the inspector's concerns, we assessed a range of reasonable options for accommodating the 1,500 from the Black Country, and that's the four. So you seem to be, you appear to be conflating two issues, if I may, but you might correct me.
Well, I think the inspector's with us that they are the same issue. You cannot provide for Black Country's needs without deleting Shropshire needs. So Shropshire needs sites previously allocated for Shropshire have been reallocated to the Black Country, and the shortfall in Shropshire needs is to be met by windfalls. But that's what doesn't add up.
That's a misunderstanding of what's gone on. We've explained it twice, madam. We hope that you've got it clear as to what we've done in respect both of the 1,500 for the Black Country and then separately for the 500 for Shropshire. We've explained it twice. If you would like it explained a third time, we'll do so.
No, I've understood what's occurred. Thank you. It's just coming up to 10 to 1. Mr. Burns, have you got lots to say or no? Right, okay. Well, it sometimes happens. I think, oh, we'll just deal with this person before lunch, and it takes a long time.
Famous last words there. Just to provide the background, as Mr. Thomas did, I represent Blore and Taylor Wimpey in respect of Tasley Garden Village, which is draft allocation, and one of those identified to meet some of Black Country's unmet needs, which we do support, unlike Mr. Thomas's position in respect of his site in Shrewsbury. Very brief point, and thank you for asking the questions at the very start, Ma'am. The issue as we see it in the with the SA is the fact that they've not a reasonable alternative hasn't been considered. That is the 1,400 dwellings plus the 1,500 dwellings. Now that was considered as a reasonable alternative in table 6.5 of the previous additional sustainability appraisal, which is GC 29. But then the new sustainability appraisal, which is GC 44, doesn't consider that as a reasonable alternative. And the council have explained why they've reached the decision in terms of the housing numbers, but they haven't explained why they didn't consider it in the most up-to-date SA. Thank you.
Thank you, Mr. Burns. Do you want who's?
Yeah, happy to respond to that. So just to confirm, so GC 29 was the sustainability appraisal report that this council prepared in 2023 to support, or to, at that time, we believed was responding positively to the outcomes of your interim findings, Ma'am, on that one, ID 28. In relation to identifying a range of options for making that distinction between Shropshire's needs and the needs of the adjoining area, the 1,500 and the 30. That was the concern you raised in ID 28. That was what we were attempting to do there. Now we actually put that into the submitted that into the examination. That led to, we won't go into the details, but that led to the protracted conversation led by Mr. Charles, actually, at that point, regarding the pre-action protocol at that point in time. Then that led on to, yeah, I'm telling you what you already know, but it's important really on this one. That led on to your ID 36. That led on to our GC 41, I believe. GC 40, I think it's GC 41, which is the council's.
Yes, GC 41.
Great memory. So GC 41, which was the council's request for clarification on those points, and that led obviously on to your clarification in its ID 37. And particularly the paragraph 5.7, which in our eyes clarifies very clearly the options you wanted us to consider, which is the SA should test based on the 2020 baseline with the 2 additional years, but obviously use those growth options that were consistent with the original SA, the 5, 10, 15% uplift, and each of those should be assessed with and without the 1500. So that gets around the challenge, which I think was identified in ID28, this idea of conflating the BC needs with Shropshire needs. It was a distinct exercise, and we have taken that as the guideline effectively for how we've assessed growth options in the SA, as I've explained earlier. So Mr. Burns is correct. There was actually an original option which we did put out in part of the original SA, which was never consulted on because it didn't get to that point, which did actually assess an option of 30,800 plus 1,500. That wasn't an option we considered this time around because we believe we are taking our lead from your direction in ID37. So roundabout way, that is why we've come with the options we have arrived at. But yeah, so that's all I have to say really on that matter.
Thank you. Do you want to come back on that, Mr. Burns?
Yeah, I understand the reasoning. It's that's what you're being directed by the inspectors, which I understand. But it's obviously up to the local planning authority to determine what are reasonable alternatives. And obviously, in the space of a year, that has been discounted as a reasonable alternative. I just can't get in my mind as to why that's suddenly disappeared as an option and being considered reasonable.
Do you want to come back at all? Or?
No.
It's now 3 minutes to 1, so I think it's probably a good time to break for lunch before we move on. And after lunch, we'll move to Mr. Roberts. Okay, so we'll break for lunch until 2 o'clock and then come back. How are people finding the temperature? Are you all right? Nobody's be after lunch when we've all eaten, isn't it? People start to fall asleep. It's quite dark and warm. And okay, so we'll break until 2. Thank you. Okay, so it's 2 o'clock and we'll resume with Mr. Roberts in a moment. What we were thinking was we'll probably deal with the essay and then we'll bring the item forward on the agenda about plan period and deal with that, and then hopefully we can deal with all that before mid-afternoon break. But if not, then so be it. And then deal with habitat regulations after the break. That means that if people don't want to stop for the habitat regulations session, you can leave. So, because I think the other two are more close. There might be people here to do with plan period, but I don't think there's that many people too bothered about the HRA position. So that's the plan for the afternoon, just so you're all aware. Okay. We'll see what we can do in terms of timings and things. Mr. Roberts.
This is against the background of our objections to 2 sites at Stanmore in Bridge North. Just for the record, they are sites STC 002 and P58A. The comments we've got to make we're going to be appearing several times in this examination, and a lot of the points that we want to make will crop up at different times. So I don't want to repeat everything all the time. I'm sure you'll be happy with that. So at this session, I'm going to simply deal with some details on the sustainability appraisal and our views on how you might take those into account or not. You'll see in the sustainability appraisal various references to exceptional circumstances, reasonable alternative sites, and the sites at Stanmore Stanmore Industrial Estate being a centre of excellence for manufacturing industry. And we shall deal with all of those separately in different sessions, if that's all right. We were concerned about the sustainability appraisal because there were various items that cropped up in it that weren't, in our view, quite accurate. And if the sustainability appraisal isn't accurate, then you don't necessarily get the right result at the end of it. First thing I should say is that if you take a look back at the strategic land assessment for employment, I think that was 2018, was it? Something like that. The 2 sites that we've just referred to and all the land around Stanmore was rejected as being appropriate for employment development. Now then, at the sustainability appraisal has separate entries for different place plan areas. And if you go to the Bridge North one, Appendix 2 of the Bridge North sustainability appraisal at page 4. And you'll see there that there are a number of sites.
Just a second, I'll just
Yeah,
catch up with you. So it's Appendix 2, page
4, I think it is. The lighting in this room isn't very good.
I know it isn't, is it? I think head torch is on, I think.
You've got lots of pretty colours on it. And the 2 sites that I'm concerned with, one is on the far right of that page. That's STC 002. And one's nearly in the middle, which is the P58A. Now, looking down the left-hand side of the page, you'll see criteria, and it's got 1, 2, 3, 4, 5, and just in respect of criteria 11 for a start, you'll see that those 2 sites are given pluses. for that particular criteria. And that criteria is that the site is wholly or partly classified as brownfield, or is wholly or partly within an area with previous industrial or potentially contaminative use. And we don't think that's correct. We don't think that's a correct assessment, and therefore the sustainability appraisal cannot give it a plus sign. And that's because both of these sites have now returned to agriculture. 58A has been in agriculture for many, many years. And STC 002 was wooded until a couple of years ago, when the land was clear felled. But in a recent planning application that was put in to develop a bit of that land in advance of whatever this this local plan exercise might do, in that application, it was noted that the site was grazed, which tends, in my view, to mean that it's been put back to agricultural use. So if it's back in if both these sites are back in agricultural use, they cannot be brownfield sites. So that, from that point of view, this sustainability proposal is not really correct. If you go back to criteria 6, which is the only other one that both of these sites have got a plus sign for, it says that, and it's only one of them that's got a plus sign, site boundaries within 460 meters of a public transport node. I don't know what the council's definition of a node is, but I think it's probably more than a bus stop. And it's correct that there is a bus stop within 460, 80, whatever it is, meters of this site, of the sites. But I don't think really that those are transport nodes, and I rather guess that they're not what was intended when this sustainability appraisal criteria was worked out. I always thought nodes were where things interchanged, but maybe the council can explain that. So those are the only two pluses for either of these sites. And the conclusion at the bottom of that page of both sites is that the score, and then they say overall settlement sustainability conclusion, is that these sites are fair. And you'll see that there are a lot of other sites there, and most of them are fair as well. There's nothing particularly special about these two sites in terms of this sustainability appraisal. And we are dealing with land that is within the green belt. And so really, if the proposal is to take it out of green belt, there must be something a little bit special about it, something exceptional that means it should be taken out. And the fact that this is fair, these two are categorized as being fair from a sustainability point of view, and that there are plenty of other sites like that as well, must mean that there's nothing particularly exceptional about these two sites. You go to Appendix 4, and they're separated by a few pages, these sites, I'm afraid. The first one's on page 100. And the second one is on, sorry, it begins on 100 and goes on for about 4 pages. The second one is page 124, and that goes on for 2 or 3 pages as well. They both make a note in the strategic considerations that the sites are greenfield in a rural setting. These are in strategic considerations. It's quite a big chunk of the assessment. Greenfield sites in a rural setting more closely associated with the Stanmore Industrial Estate. It is physically, and this means they because it's the same wording in both, physically and functionally separated from the development boundary and the built form of Bridge North by Stanmore Industrial Estate, Stanmore Country Park, agricultural fields, and the Hermitage Ridge, and in brackets, and associated ancient woodland. So really, what's that saying is that there's quite a bit of separation between Bridge North town and these two particular sites, which the council are presenting as serving the needs of Bridge North Principal Centre. Then it says the site is located within the Greenbelt. The NPPF specifies that Greenbelt boundaries should only be altered where there are exceptional circumstances, where exceptional circumstances are fully evidenced and justified, before concluding that such circumstances exist, and all other reasonable options should be examined fully. As I said, we'll be giving you information about our view of the exceptional circumstances that the council have come up with in later submissions. And then a little bit further down that page, in reasoning, this is on page 102 now. The site and it's similar wording on the other one, not precisely the same, but similar. The site is well related to Stanmore Industrial Estate. Don't disagree with that. An existing employment area, which is inset within the green belt. And then just to make the point, they say Stanmore Industrial Estate, which is inset into the green belt. So they make the point twice. Doesn't really need making twice. And then they go on to say, it's a very successful employment site and represents a centre of excellence for engineering and advanced manufacturing. There's nothing in these criteria that could lead you to that conclusion. So the council must have concluded that for some reason or other, don't know. We'll be making noises about whether there is in fact, whether it is in fact a centre of excellence and whether the opportunities there for advanced manufacturing really do exist. But in terms of the sustainability appraisal, I don't think there's anything in those other questions that have been answered and the criteria that were set out that would lead you to that conclusion. So I don't know why the council chose. I can see why they chose to put it in, because they have put it in several times in the exceptional circumstances argument. But I don't know why they would have included it in this argument, because you wouldn't draw that conclusion from the answers to these questions. Right. There's an answer to a visual and landscape consideration in the criteria on those appendices there. And the council have concluded that in terms of visual landscape consideration, they've been categorised as medium. But in fact, in Appendix 4, employment thing, impact on visual and landscape consideration from employment is medium and high. So there's a slight difference of opinion somewhere along the line. Then in both of these cases, they record that the Greenbelt assessment that was carried out when they looked at all the various land parcels in the Greenbelt, when they were trying to assess the possibilities for taking land out of the Greenbelt. And these two sustainability appraisals record that development of these sites would cause moderate harm to the Greenbelt. Well, moderate harm is still harm, and I don't recall any subcategorization of harm in the framework. And so we're back, in fact, to exceptional circumstances. And the fact that they've concluded from the sustainability report that there's a moderate level of harm shouldn't be a reason for saying that's okay. Because the NPPF doesn't say that moderate harm is acceptable. We've taken a look at, as I said, several different aspects of this development. And the one thing that and although it's being presented very much as helping Stanmore Industrial Estate, that's the basis on which most of the exceptional circumstances are being presented. We've had difficulty finding great evidence that the estate is, first of all, highly successful at the minute, or how big the demand for more units or more floor space on the industrial estate actually is. There was a comment in the local plan that the council had been in touch with the, I think it was the agent that deals for the Stanmore estate, and he said there's big demand. We haven't been able to find any evidence of that demand, or any figures, or any expressions of desire to move there. And unless that's there, we don't think that what has been put in the sustainability appraisal is a good basis for you to decide that these two sites should actually be taken out of the green belt. I think that's all now.
Thank you, Mr. Roberts. I'll ask the council to comment on that scoring, and particularly that there's that discrepancy between greenfield, brownfield. Maybe explain where that comes from.
Yeah, if I pick up that particular query, the essay objective that has been referred to is about whether it's brownfield land or previously contaminated land. The council maintains a database of previously contaminated land, which includes the entirety of STC 002 and portions of P58A. The specific classification is previous industrial site 1945 to 1970, military land. Obviously, the Stanmore Industrial Estate itself was a former airfield, and these parcels contain parts of the site that, whilst have been subject to some remediation, are still considered contaminated from the council's public protection perspective. So that objective that is being referred to, the indicator is it brownfield or is it previously contaminated? And it's considered to be previously contaminated, hence why the opportunity to potentially address that contamination as part of a redevelopment is seen as a positive within the sustainability appraisal objectives. Oh, yeah, sorry, and the other issue that was raised about the transport node, I can confirm that is it's dealt within the sustainability appraisal environmental report, and it just confirms that a transport node is just that. It's a bus stop or a train station with a regular service, and there is such a facility within proximity of the site. In fact, it's right outside the Stanmore Industrial Estate. There's an active public transport link there.
Sorry, Mr. Robert, can I just ask you to turn your microphone off? Because I think the others, it doesn't sound.
Is there any other points you wanted us to come back on? I note that there was quite a lot of detail there, which was potentially going into different bits of evidence, which might not be on the table today, but we're sort of in your hands if how much you want us to respond to some of that.
Just quickly run through what was said. If there's anything else that, some of these things I can kind of check myself as well, but. Yeah, I think that's probably covered points that relate to essay and things.
Yeah, there was one final.
Yeah, sorry, just one of the other points that was picked up was about the landscape assessments. I've just had a quick look, and basically both of the parcels are within one parcel that was in the assessment, but one of the sites, P58A, goes into another parcel, hence why it's got two different landscapes scores, because it's in two different parcels, so it's considered in two different assessments. That's in our EV 71.09 is the appendix for Bridge North. But that's the distinction between the two sites. Basically, part of one of the sites goes into another parcel, hence we've taken into account the rating for both.
Thank you. Do you want to come back on any of those? It sounds like they're on a register, so the councils hold registers of contaminated land, and it seems like it goes back to the sort of wartime use as a military airfield. Is that?
That's entirely correct, yes.
Because of the way the wind blows in Shropshire, and I've been involved with quite a few of them over the years. I haven't known any one of them yet be accused of having contaminated land such that it cannot be used for something. And this thing says potentially contaminated. Well, if you're going to allocate some land for something, you want it to be a bit more than potentially, don't you? I would have thought.
Yeah, I think what normally happens is there's that potential, and then whoever develops it, there'll be that requirement on them to assess what it is and remediate it.
Yeah, but by that time you've got an allocation for employment. That's a bit late then.
Right. Okay, I hear what you say. Do you want to come back on any?
I don't think there's anything we need to come back on there, aside from saying I think we'll be picking up employment allocations in a separate matter, and obviously I'm sure you'll want to hear a bit more about the exceptional circumstances at that point, perhaps rather than now. But is that reasonable?
I think we've covered this sort of sustainability appraisal stuff, haven't we? And you said you'll come back on other days. And
oh, indeed.
Thank you, Mr. Roberts.
Thank you.
If you can just turn your microphone off. Thank you. And now we've got two people from CPRE, haven't we? I don't know who wants to speak, or are you doing a bit of a double act? Or
I'll go first. So I'm Charles Green from CPRE Shropshire, and primarily addressing your question 3, which is, have any concerns been raised about the updated essay methodology, and what is the council's response to these? So our main point is a more fundamental point than just detailed considerations, for instance, of the treatment of windfalls. You have our written submissions, and if I may, I'll just briefly summarise in probably about 3 minutes why we think the conclusion of the sustainability assessment is flawed. We're not going to quibble with the options that were chosen, although you could argue about some of the actual fine detail of percentages on that, but essentially they have assessed options 1A, 1B, 2A, 2B, 3A, 3B, and the council has concluded from an intricate scoring system where right at the end they ducked the issue. So the council has concluded that option 3B for the highest growth was the most sustainable option, both for housing land and for employment land. And we say in our evidence that this is at odds with the council's own underlying evidence, which actually indicated that it was option 1B for the lowest growth that was the most sustainable option. And this issue goes to the heart of what sustainability appraisal is about, which is sustainability. So we think the council has come to the wrong conclusion, and we say that the illogicality of the council's conclusion stems from the fact that it avoided or ducked showing totals for tables 8.7 for housing requirement and table 9.7 for employment land requirement. And you've just actually seen in marked contrast from looking at those Bridge North detailed sustainability assessments at stage 2 assessments, that the council quite happily depended on totals in those stage 2 assessments, which were essentially scoring the same 16 sustainability objectives as where they've plumped for option 3B. And I'd say there was no pleading in that case that there are more sustainability objectives that address environmental topics than social and economic topics, which is essentially what they're pleading by not producing totals in tables 8.7 and 9.7. And they say that the totaling up of scores there would create a bias towards environmental factors. And it's for that reason that we say that Shropshire Council appeared to present a predetermined outcome, and that the sustainability appraisal has the appearance of being an elaborate sham. So what is the second part of question 3 is, what is the council's response to these? So what is the council's response to these points? And I don't think the council has not really addressed the arguments we put forward, either in GC 52, which is the summary of the responses on the additional material, or in M1.01, which is its response to ID 40, these stage 2 matters, issues and questions. In GC 52, it only really repeated the reasons that we were critiquing without properly addressing them. And that effectively this highlights what we've been stressing throughout this plan process and examination process, that the draft plan seeks growth well in excess of demographic need, which is not truly sustainable because it is at odds with both the climate emergency and the ecological emergency. And it has targets for both housing and employment land that are unreasonably high based on figures that are questionable. So fundamentally, the high growth strategy is not supported by the sustainability appraisal, but Shropshire Council has chosen to let the economy trump the environment. That's the substance of our main points, but we, in this session, we seem to have touched on matters that are perhaps we would have thought would be dealt with in matter 2, 3 and 4 on development strategy, housing need, employment need.
I think naturally there's overlap in all these sessions.
Yes. So I think we do have things to say on that, but perhaps the council, do you want the council to come back on the main point first?
So I will do. I think some of these points we covered in stage 1 hearings, didn't we, this criticism that the council addressed. I think it's not a new process.
It's a new point.
Can you let me speak, please?
Yeah.
I think it's not something new to this particular addendum, updated essay that wasn't in the old one, if you see what I mean.
That's completely correct. Ma'am, this was, I believe, an issue which was dealt with on the stage 1, matter 1, I think. And as we've as we set out in our matters and wider evidence, that the approach we've taken to the additional essay report is consistent with the earlier essay report. So we have a response to this about, it is, I think Mr. Green's point is we should be adding totals up. Our response to that is, John pointed, it's more complex than that because of the weighting of the balance between the essay objectives. There are more environmentally based essay objectives than economic, so we do need to weigh that in the balance. So it's slightly more nuanced than just adding up things at the end of the day. But effectively, yes, I think we have responded to that point as part of stage one. But if obviously, we're in your hands if you wanted us to respond on any other points.
Thank you. Do you want to come back on to Mr. Green?
Yes, thank you. I think the point was that the whole thing became more apparent at this third iteration of the essay. I think the original essay as submitted with the Regulation 19 submission, I think, did not attempt the final stage, which we have now totaled up. I think at the second iteration of the essay, it may have done, but because they have now assessed those 6 different options, it became much more apparent what was being done. So to that extent, it is a new issue.
Do you want to come back on that?
Yeah, if it helps, within our response to the issue when it was raised during the recent consultation, we sought to explain why we haven't done that adding up process that you're advocating, Mr. Green. And effectively, it comes down to the fact that first and foremost, it's important to consider each essay objective in and of itself. And there's a real risk that if you total them all up, you're losing the detail in that conclusion. As my colleague, Mr. West, has already recognised, there are significantly more environmental essay objectives than there are economic or social, which is perhaps not surprising. But what it does mean is that if you try to total it up, there's a risk that the social and economic pillars of sustainability were disregarded. And as we all know, the point of sustainability appraisal is to try and achieve balance across the 3 pillars. So that was the reason for why we don't do that step that you're suggesting as the final step. What we do is we look at the results of the essay, look at the assessment against each of the objectives, and then reach the conclusions which are detailed within the essay itself. So GC44 explains how we've considered the performance of each option against the objectives and why we recommend one option being more sustainable than another. And then the final step in the council's perspective is that we then undertake the planning judgment exercise, which is we look at the results of the essay, consider other relevant factors, and that's again all detailed within the Housing and Employment Topic Paper GC45. And that's why we've reached the conclusion with regards to the recommendation that option 3B is the most sustainable and the most appropriate option to proceed with in terms of the housing requirements. Just the one issue that Mr. Green raised about why in GC52, which is the summary of the responses, we cross-reference the essay rather than providing new responses, if you like. I'd suggest that if we didn't do that, if we hadn't made it clear within GC44 why we'd taken the approach, the question would be, why have you not explained why you've undertaken that approach within your essay? So I think it's perhaps unsurprising that we then explain or point to where we've already addressed these issues within the essay, because we've sought to provide a clear explanation of the approach that we've undertaken within the essay itself. So our response to the questions are, it's explained within the essay, and this is where it's explained. I think that's perhaps unsurprising because we tried to explain the process that we've undertaken within the document itself.
Thank you. I think that covers everything. I realise there's a difference of opinion, Mr. Green. I've heard both what you've said and what the council said.
There's also a disparity between what they've done in the main essay and what they've done in the stage 2 assessments, which you've just been taken through in detail. In those stage 2 assessments, they do a simple total. They do not take this point of this, whatever Mr. Corden means by in and of itself. Each sustainability assessment, each sustainability objective is given equal weight in the stage 2 assessments. My point is that they have chosen not to do that in the overall assessment because it doesn't give them the answer they want.
So you want to come back on that point, why you've done it in one stage and not the other?
I think Mr. Green is referring to the approach we take for sites as opposed to the approach we take for strategic matters. And I think that's the explanation in effect. It's a different process assessing various options for levels of development, for instance, and it is which site should accommodate development. I think that's why we're taking a different approach, because there has to be nuances between the two. But importantly, the results of stage 2A of the site assessment process are then considered in the context of wider planning judgment within the stage 3 assessment. So it's not that the results of that result of that essay process is not given further consideration. It's considered in the context of wider issues that are identified for the site. We talked about things like the green belt, for instance, which isn't an issue in the context of the essay objectives, but clearly is a planning consideration that needs to be given due consideration in the site assessment process.
Thank you, Mr. Corden. So does that conclude everything you wanted to say, Mr. Green?
Well, other than it's up to you, I suppose, in your final report as to whether you consider that the Shropshire Council has chosen to let the economy trump the environment when we're in a climate emergency and a biodiversity emergency. Thank you.
Thank you. I can't see. Is it Mr. Keller?
Oh, got it. Sorry, wrong one. I'm going to touch on matters. I'm aware that this will go over into matter 2 and 3 as well, but I think given what's been said, I wanted to pick up on this issue of the Black Country overspill. And the first thing I want to pick up on a couple of points. The first thing is what Mr. West has been saying today quite clearly, which I don't think has been said as directly by Shropshire Council up till now. And it's what the man on the Clapham omnibus would tell you that he knew already, is that the people who move to Shrewsbury will get jobs in Shrewsbury and work in Shrewsbury, and this will be migration. And I just bring you to 2.22 of their statement. It's the matter 1 or the matter 2 statement. It's the matter 1 statement, where they set out what they have been assessing in terms of the Black Country geography and the things they've been considering, the migration patterns, the commuting patterns, and the travel to work areas. Now, I have the same difficulty with this place plan areas of just how big they are to make an actual assessment of people travelling into and out of the Black Country, but it seems something more fundamental is now being said, that it's not the intention that these people will commute into the Black Country, that it won't be a question of the travel to work area. As we know, Shropshire is not part of the GBCHMA, Greater Birmingham Housing Market Area, it's beyond it. And so it appears that the criticism that actually this is not supporting the Black Country need for housing comes into play. We know that other authorities, and I've been at inquiries dealing with them, who are providing housing or have at times offered housing for the Black Country, are providing it on the edge of the Black Country, i.e. literally where we know that in reality people will actually live and work in the Black Country.
So clearly, when one is considering this sustainability, one has to consider it both in terms of the sustainability for Shropshire and also for the implications for the Black Country, which of course needs to retain exactly the kind of people who I would argue might well move out to Shropshire so that it has a balanced population. And this is a matter, importantly, for the sustainability appraisal as to whether moving these 1,500 houses to this place, not as places which we know will actually be linked to the Black Country, but will not be, is justified. And this is the correct approach to take. And I would just take you over, just to follow on that point, to GC 45, 6.6. When it assesses the contribution of 1,500, and it says, positively responds to the relationship between Shropshire and the Black Country, geographic infrastructure links, migration patterns, and commuting patterns. Well, I don't think the evidence of what we've heard today was that that is what we will see in reality. And I live in the Black Country. I'm sure that's not what we will see in reality, because that's exactly what will happen. And that's why the different approach we've seen to housing and employment seems to be acceptable. But that brings me on to another 2 points that I'd like to make on this, which relate to the sustainability of it and to the whole approach, I suppose. The second thing I want to take you, if I might, to the statement of common ground we now have. And I hope I'm getting this right, because I've only seen it today. But the first thing I notice about the statement of common ground between Shropshire Council and the Black Country authorities is that there is simply no unmet need. There's no figure for an unmet need. When we address this in the stage 1 hearings, you were being given figures of what was considered would be the unmet need in the Black Country, how that might be addressed, and why there was shortfalling, and therefore why it might be needed to be met in Shropshire. We don't have this in this statement of common ground. We don't even have reference in this statement of common ground to the plans that are actually in play in train, where you might say we have some knowledge about the housing shortfall. And I have to say I'm represented CPRE on a couple of those, and we've made comments about those shortfalls and the extent to which we think they're correct. But leaving that aside, one thing that would be quite clear from that would be that the shortfall is not across the whole of the Black Country. In fact, the vast majority of the shortfall, approximately half of it, is in Sandwell. So you have to consider not whether Shropshire should have a duty to cooperate with an organisation which is not a local authority, but whether it should have a duty to cooperate with the local authorities in the Black Country which are producing their plans. And that brings me to the end of their statement of common ground, which is quite clear about the process for this, which I was not aware of until this morning, which is part D of 5.1, says the manner in which the unmet need contributions are distributed between the 4 Black Country local authority areas is a matter for the Black Country authorities to be agreed through duty to cooperate engagement between them. So this is a very strange process, because we're not making a duty to cooperate between Sandwell and Shropshire, or Walsall, or Wolverhampton, or Dudley. Dudley, of course, has virtually no, even on its own account, no unmet need. But we have this strange process through which we are providing a housing number for a figure that we don't know. Now, I want to just come on to one other point then on this, and may come back, because this sort of is a theme through it, which is the evidence that we now have in relation to the unmet need across the conurbation. Now, we have some evidence on the Black Country, which is to say what is in the plans that are coming forward, which is largely 18,000 in Sandwell, 1,000 in Dudley, and I think it's about 9,000 in Wolverhampton, but that is subject to change. It relies on the 35% uplift, which may not happen by the time Wolverhampton's plan comes through anyway. So we don't know, but we do know that the majority of it is in Sandwell, if it exists. But the other thing we've had two things that have come forward, and there's no evidence of any discussion between Shropshire and Telford, firstly, in regard, and you've got the details in our statement, in regard to the extreme difference between the standard methodology in Telford and the amount of...
I think what we're straying into here is duty to cooperate matters that have already been resolved, I think.
Well, these weren't, this wasn't before us before.
This session is about the essay, it's not about the DTC.
Okay. Well, sorry, if I can just finish, because it rounds off the point, and I'll come, I know it covers the point, and it's in my evidence for Matt too, so maybe it's better to come back to it then, is that we didn't have the evidence, both in regards to Telford, which would obviously, in my Clapham omnibus man, be an equal place. Equally, we did not have the evidence of significant additional supply in Birmingham to the extent of 30,000 homes in their latest preferred option, which nobody at this examination has referred to that I can see in any of their statements, which makes a huge difference to the ability of the conurbation to meet its needs, and therefore to whether there is any need for Shropshire to be meeting need in the Black Country, which would be better meant in Birmingham. So my final point, if I may just say it, therefore, is you may say that the June evidence was before the evidence that there was more housing supply in the conurbation came forward. This is dated October 2024, this statement of common ground between Shropshire and Black Country. There is no obvious evidence that it has taken account of changes in the supply that were evident both to the Black Country and to Shropshire Council, which could then have informed this process as to whether that 1,500 was needed, and therefore as to whether that was the most sustainable option. And this is where I come back to the sustainability appraisal, when there were other options for meeting that housing need, which would be more sustainable. So that's my point.
Thank you. As I understand it, those figures are still not tested. So when we spoke at stage one, they weren't tested. So and again, they've still not been through examination. So they're still just.
Yeah, well, exactly, ma'am. When the 1,500 was set up, it was set up on untested figures. These are untested figures. They're no more or less tested than those were.
Thank you. Does the council want to? I'm not sure there's anything particular.
I'm not sure there's anything particular, apart from obviously this is clearly straying back into the DTC conversations. Clearly, when we had the stage one conversation, representatives from ABCA were there, and I think spoke about the conversations with us and the need and that conversation. As you say, Ma'am, that those numbers haven't been through examination. Not a lot of examinations happening in the West Midlands at the moment. I haven't really got anything else to say apart from bring back regional planning, I think, on this one.
Although untested, there is a figure before you for unmet need in the Black Country. It's in the first statement of common ground, paragraph 711, where he looked at that at stage one.
Thank you. That's helpful. Moving on to Ms. Colcord, or who's, feel free to choose who, because I think you're in sort of groups. Are you on that table?
We are, yes.
Yes, yes,
Yes. To do with that,
right.
Disowning me.
It's hard to see everybody's nameplates and to see who's acting for who. So, right, brilliant.
Well, Madam, good afternoon. My name is Selina Cahoon. I'm counsel for the Stanmore Consortium, and I'm instructed by Mr. Pocock, Vincent Masons. Just a few points, and forgive me if I do stray into some of the points that Mr. Kells has raised. The principal submissions obviously do relate to the legality of the SA, and part of your consideration, simply as a matter of law, will have to be whether it has been effectively reasoned, and not only with regard to the reasonable options, but the choices that come out of that. So that is a given. And in particular, with regard to where we are now, and given the points that you have raised, it is essential to understand that Black Country need, what that means, and the implications of that. So that is the focus of my questions, and I've got, or issues that I want to raise, and they fall into three principal areas. The first, I'm afraid, does touch on the duty to cooperate, and I completely understand that back in February of 2023, you drew your decisions with regard to whether the council had met that duty to cooperate. But Madam, the duty to cooperate is obviously an ongoing duty. It doesn't just stop either at submission or indeed at a decision on stage one. You need to be satisfied, Madam, that that duty to cooperate has been ongoing. And at the moment, the only views that we have of the authorities since January 2023, and I took the time to look at that hearing and saw what those authorities said. But the only thing that I could find that is before you since that time is the statement of common ground that has just been signed. And Madam, that what we don't have, again, as I understand it, I'm very happy to be corrected, is any formal response from any of these authorities to the essay consultation or indeed any of the topic papers. So you, Madam, don't know what the authorities think. And when I say the authorities, I do mean the Black Country authorities. I know there are others, but I'm concentrating on the Black Country authorities. You don't know what they thought of the SA and the Green and employment topic papers, housing and employment topic papers. What you do have, obviously, is the Statement of Common Ground, and it sets out in very slim order the views that what has been done is seemingly appropriate. However, Madam, what you don't know still is what level and type of engagement led to this Statement of Common Ground. Madam, I do this in order to be helpful. Clearly, in my submission, you need to have an update on the duty to cooperate, because this Statement of Common Ground doesn't explain that. It is a principally summary submission and doesn't really help you understand, firstly, why it is that they consider the outcomes of the essay appropriate. But Madam, setting that aside, the second point that I wanted to raise is it comes to what Mr. Kells raised, which is a point made by Mr. West, I think it was, in understanding the difference. He was very keen to say there's a clear difference between the commuting as an issue with regard to identifying suitable employment sites, and commuting as an issue for identifying housing. And Mr. Kells pointed to that paragraph. Forgive me, the note that I had was 6.6, I think it was, of the, whoops, I've forgotten which one it was. Mr. Kells can probably remind. But clearly there has been emphasis on the functional relationship between certain areas of Shropshire and the Black Country. Now, that functional relationship does not mean, in my submission, simply migration as a wider issue. There does need to be an understanding as to why these sites meet that Black Country need. And that is based upon a functional relationship, which in my submission is obviously related to how you get to and from the Black Country, not, madam, those who are coming or migrating to Shropshire and staying there, leaving, in effect, the Black Country. That is not an issue of meeting Black Country needs. Because migration, madam, is dealt with when you look at overall housing need. That is factored in. So it is actually clear that the essay should have been based, when looking at housing, just as much as looking at the employment sites, on the ability to commute in and out of the Black Country. And so I ask you to question that position taken by the council, because if migration was all, we'd be back to where we were before you raised your questions, which was somehow the Black Country need was going to be addressed across the whole of Shropshire. There needs to be a specific link, and it needs to be addressed. And at the moment, we simply don't see that in the reasoning of the essay. And the third point that I wanted to make, Madam, I'm sorry, I think I'm adding to the hearing statement. I don't want to repeat any of that, but certainly, sorry. In terms of the third point, this comes down to the question of, I think it was Mr. Charles who raised this notion of deallocation. I don't call it that, but there is a clear identification of local need within many of the PPAs, including Bridgnorth. And this is a point that is raised in our Matter 3 response, Madam. It's paragraph 213, page 5 of our Matter 3 response. The issue is that there is a demand that has been identified on a local basis. In Bridgnorth, it is some 1,800, well, a figure of 1,800. And to the extent that 600 of that 1,800 is now to be given over to the Black Country, as it were, it is clear, therefore, that the full local needs of Bridgnorth are no longer to be met as a consequence of the outcomes of this essay. And so we ask that the council addresses that and explains how that is reflected and why that makes sense. But lastly, and this comes out of the HE Statement of Common Ground, which is SOCG 16, there is an overall employment land requirement, but we now know, as a consequence of this latest SOCG, that the site in just to the east of Shrewsbury, SHR 166, comes out of that land requirement, well, land allocation, and that, madam, is 45 hectares, I'm instructed. So at the moment, you are being told that the employment needs of the area of the local plan are simply not being addressed. So that is a further lacuna that we say you need to be satisfied of before concluding that this essay, and the plan is sound. Thank you, Madam. That was all.
Do you want to speak? No, that's fine. Okay, I'll come back to the council then to address some of those.
Okay, thank you, ma'am. Just a few points just in response. The on-running DTC, I don't really want to draw too much into that because we have dealt with that issue, and slightly frustrating that it seems to be brought up again today, but it has been, so we'll deal with it. Shropshire Council, as we said last time, continues to attend meetings of the Housing Market Area Planners Group. It's an on-running conversation. There's actually a meeting happening now. It's the first one we haven't not attended because we're obviously in a hearing session instead today. We felt that was more important than that other conversation. You'd be pleased to know, I'm sure. So that conversation has happened. The purpose of the addendum to the statements of common ground was to reconfirm those proposals and that agreement. They did, all those authorities were consulted on the new evidence. They have chosen not to respond. We can't, that's up to them if they want to respond to a consultation or not. But I think it's pretty clear from the addendum to the statements of common ground, there was, they had no issue with the outcome from that process. I mean, they continued to reiterate their objection about the plan review as well. So I would point out that, and so that's clearly something we don't agree on as well. So that is just evidence that we have had that continued conversation. If that evidence of agendas and our participation at the those events since January 2023 is needed, we can provide them. We felt as though that issue had been put to bed, but if it's needed, we can provide them. The second issue on my list, and I'm sure people will say I'm missing something here, about the difference between migration and the issue of wider commuting. We recognise there's a number of issues around a functional relationship with a neighbouring area. Okay, we have set out in our matters those issues which we took into account. The point I was making earlier on, that there is a distinction between people who will seek to arrive here for work and people who will arrive here for in terms of living here as well. So that was just a point I was trying to make earlier on. There is a distinction, okay, but both were considered within the round. The figure which you referred to as the 1800 figure for the S3.1, which is the development strategy for Bridge North, which identifies a localised housing requirement of 1800 dwellings. That doesn't necessarily reflect local need. That's a localised housing requirement at that point. So again, you know, we have had conversations early on in this examination around the distinction between need and requirement. That's another one of those issues there. SHR 166. I assume we will be dealing with that under matter 4 and matter 26, I think, separately. So we recognise it's absolutely it needs a discussion, but perhaps not in this matter, unless obviously you wanted that.
Yeah, I think that's the place to discuss that in more detail, isn't it? I think we've made everybody aware today that what's happening, isn't it? And yeah.
Is there any particular points that I've not raised or not come back on which you want us to?
Just very quickly, Madam. As I said, it is clear that the duty cooperative is an ongoing legal requirement, and I would suggest to you, Madam, that you do require proper evidence of that ongoing duty being complied with. So I think that is something that if you're going to find duty to cooperate has been met, then you need the evidence. I think I understood what Mr. West was saying about the issue about commuting and migration. What he ended up saying was that there's a distinction between those who or how you assess the needs of those who move to live in Shropshire from the Black Country and those who are arriving for work. Well, Madam, both of those do need to be addressed on the basis of how they are moving in and out of the Black Country, and therefore commuting must be an issue of where you best place the sites that are to address that need. Otherwise, again, could be, I think the example that Mr. Hopkins gave, they could be coming from Kent. Commuting and the distances between and how you travel to and from the Black Country are essential to whether something is meeting the Black Country need or not. And forgive me, Madam, I think I missed the point about the figure of 1,800 identified for local need in Bridgnorth, but I believe Mr. West said that this may be a need-based figure, but it is not a requirement. But I
think it was
that
the
is
other
not
way
an
around.
answer to the question. Oh, sorry. Oh, it's a requirement, but not a need.
It's not a local need to Bridgnorth, as I understand it. It's a requirement that's sort of been given to them as part of
It's a recognition of Bridgnorth, its role within the east of the county, and the opportunities that arise there. We have an opportunity through plan making to identify suitable localised housing requirements as a subcategory of the overall housing requirement. That is what that seeks in achieving. It is not a recognition of defined local need in an area. Is that suitably clear?
So, Madam, we are being told, therefore, that figure is not being, or is part of that figure is not being addressed through the allocations, because 600 of those of that need is being met, is being directed to Black Country need.
I think it's part of the overall need for Shropshire. Is what I understand, rather than it's not Bridgnorth that suddenly has a need for 800 more.
No, you're exactly right. As delightful as it is to hear my learned friend Ms. Colquhoun riff on the subjects of the duty to cooperate and the need in Bridgnorth, none of this is in their matter statement for matter one.
Madam, that is because the statement of common ground was not issued until last night.
Then that's all the more reason for it to be in matter one, because you ought to have been pointing out that there was no new statement of common ground in matter one if your clients were really worried about it, not coming up today and riffing on it because you think it might be a good point after all.
Madam, I'm not going to rise to this.
Thank you.
Can I join in?
Is it something the same or different?
Well, it's directly relevant.
We're not. I don't want to get into a DTC discussion, because that's not what.
And I'm not going to repeat Mr. Reid's submissions from last time round. So it's a point of clarification. 5.1a of the new statement of common ground just issues says that the Black Country authorities continue to view 1,530 as being appropriate. My understanding of that is they're saying that's appropriate. They're not ruling out that a higher figure might also be appropriate. I don't think it's a cap. I think it's a statement of so far as it goes. My question for Mr. West is, if he's been having all these ongoing meetings, did none of those ongoing meetings discuss whether 1,530 could be improved on or increased? Because it was always the Black Country authorities' position that 1,530 was a starting point, not end of.
I don't think as part of this examination we want to start looking at higher numbers for the Black Country need. We could, these examinations go on long enough as it is, start readdressing constantly. You know, it could go on forever with that number and this number and that, and before you know it, the examination takes 10 years or whatever. It's I think we have to just draw a line under that. That's what was agreed. I've accepted that in a letter, and yeah, and as I've said, it's for future discussions. I think once figures are known, so over the coming years, there'll be examinations in relation to those various plans, and those figures will become crystallised more, and people will know then, like you say, where that need is actually coming from as well, rather than it's at the moment it's a general pot, isn't it? We're looking at by then it will be narrowed down into those particular areas, and who knows what those numbers will be when we get to, you know, a new MPPF or whatever. So I think we are where we are at the moment, and we don't want to take a lid off that again because otherwise it's never ending. Does the council want to say anything on that point?
Madam, can I just ask you though to require the evidence of the ongoing duty to cooperate, because I think you do need it.
I hear what you say on that point. Thank you.
Mr. Manley, representing Bonningdale Homes, ma'am. Thank you very much. Ma'am, our interest is in sites P36A and B, emission sites at Albrighton. Can I just say before I make my brief comments that I do adopt the submissions of my learned friend, Miss Calhoun, and I want that on the record that I agree with what she said. I'm turning to question one, the adequacy and accuracy of the essay. We think there are perhaps, in essence, three very pithy matters that the essay does not address in any meaningful sense, and indeed should address. Firstly, some bald facts, because it's good to remind ourselves of some basics. The proposed Shrewsbury site allocation is actually 33 miles from Wolverhampton. I take Wolverhampton as a proxy for the Black Country. And Dr. Google tells me it's between a 50-minute and 1 hour drive. There is a train in Shrewsbury, of course, but it's on the other side of town to the site. And you heard today that not even the site promoters of the Shrewsbury site believe it can sensibly meet Black Country needs. Indeed, it was originally allocated to meet primarily Shrewsbury's area requirements. The Ironbridge site is 26 miles away from Wolverhampton. It has no trains. Again, my friend Dr. Google tells me it's a 40-minute car journey. Bridge North, a lot closer, 50 miles from Wolverhampton, half-hour drive. If the authority are right, ma'am, about these sites meeting or at least contributing to Black Country needs, and it's a big if, then that implies an awful lot of commuting. Now, we know it implies a lot of commuting because if you look at the site-specific assessments for each site, the very last question asked in relation to any site is potential to accommodate housing as part of the proposed contribution to Black Country. And in relation to Albrighton, it says this: given Albrighton's proximity and strong transport links to the Black Country, this site could be suitably located to accommodate some of the proposed contribution to the unmet development. In other words, a direct connection is drawn between a site that's meant to be meeting the Black Country needs and its accessibility to the Black Country. So there's an implied recognition that there's going to be quite a lot of movement between the two. Now, that being the case, at no point does the SA involve itself with what will be the environmental effects of all those additional lengthy car journeys, CO2 emissions, and all the rest of it. If I was putting in an application for 1,500 houses on the site, I'd have to submit an ES, and it would inevitably have an air quality section in it. I wouldn't get it validated otherwise. So that's the first failing. The second one is the distances imply, ma'am, a clear potential social impact by reason of distance. Because people will be moving, being forced to move in effect to find accommodation away from family, friends, work, support networks, all the other things that we all enjoy in the Black Country. They're going to be an hour away if they're in Shrewsbury. There is something also that's not been touched on at all so far, a third point. It's the Bridge North site, which of course is a commitment, so it's in there quite rightly. But that site is only committed to 5%. Ironbridge, sorry, is only committed to 5% social housing. It's got various reserve matters applications, I think, coming in, and they commit to 5%. That's on accepted evidence of viability. But nonetheless, when you are looking at meeting Black Country needs, and as I understand it, affordable needs are quite a significant component of that, then your SA should be asking itself what kind of role a site that can only pull its weight to the tune of 5% in that regard, what value that has, what impact that has on the social needs that the SA is trying to address. It doesn't engage with it at all. The second point I want to turn to, Ma'am, is question 2, reasonable alternatives. Ma'am, if one starts from the position that a reasonable alternative in law is something that is either preferable in some way to the preferred site options or environmentally equal, then I have to say, with the greatest of respect to the authority, that I struggle to see how the sites have been chosen and my client's site has been dismissed. And I'm not going to repeat the comments I've made about distance. They obviously weigh in favour of the Albrighton site, because that's only 8.5 miles away from Wolverhampton. And the site assessment recognises that there's good connectivity. But of course, it's a greenbelt site. It's also, I should say, very close to the greenbelt release at Shirehall for employment purposes. If you were to turn, and I don't ask you to do it at this stage in the afternoon, I give it you for your note. If you were to turn to tables 1 and 2 of our submission on this topic, on matter 1, you will see that the sustainability appraisal scores my site better than any of the allocated sites. No ifs, no buts, it scores better. And that's on the council's own matrix that doesn't give any particular loading to proximity to where the need arises. So what is bound to ask when you look at a site and see that hands down it trounces the preferred sons of the authority? Why isn't it in? What's going on? Well, firstly, the site-specific assessment of my site says it's not known if it's available. Well, it is. It's the subject of an application. We've agreed with the authority that they can have an extension of time to the 29th of November to determine it. The only other reason for not putting it in, and it's stated quite shamelessly, is that it's in the Greenbelt. Fine. But 2 points about that. Firstly, the Greenbelt assessment actually notes, in respect of this site, that it has potential for safeguarding. In other words, the authority themselves note that the green belt role and function of this site does not necessarily trump development needs. Otherwise, they wouldn't have suggested it came out potentially for safeguarding. And secondly, this is a plan that proposes to release Greenbelt for employment, Shifnal, modest Greenbelt release at Alverley for housing needs, and more extensive Greenbelt release for safeguarding. Now, the Greenbelt topic paper, which was written in July 2023, so it was written ahead of the updated essay, simply asserted at paragraph 16 that any more Greenbelt release wasn't necessary because there were more appropriate locations. The document doesn't explain what that means, much less how the conclusion is reached. But in the context of Black Country needs, the proximity of the site to those needs and the remoteness of the proposed sites should have been transparently balanced against Greenbelt status, along with the fact that the site otherwise scores more highly than the preferred sites of the authority. But it wasn't, never was. It was just dismissed on the basis it's in the Greenbelt. That is a wholly inadequate and unreasonable response to the assessment of a site which, on any view, taking the legal definition of what a reasonable alternative is, it's a wholly inadequate response to something that patently is a reasonable alternative. I don't think I need to trouble you any longer, Mel. Thank you.
Thank you. Did you want to speak as well, Ms. Wilson?
No, I'll let the council come back.
Okay. Can you just turn your microphone off?
Oh, I'm so sorry, Mel.
And then I'll ask the council to come back on those points. Quite a lot of points there.
Thank you, Ma'am. In the first instance, with regards to the distance of the sites from the Black Country, as we've already explained previously, the first stage that the council undertook in identifying where reasonable options would be located was to look at connectivity and links to the Black Country, proximity and links to the Black Country, sorry, migration patterns, commuting patterns and travel to work areas. Those factors were used to identify reasonable assessment geography within which reasonable sites would be located. So that's how we identified the reasonable options to consider in the context of accommodating the proposed contribution to the Black Country. We then assessed all the sites within that area, including the sites represented by Mr. Manley. And through that process, that considered connectivity to the Black Country as one of the factors. We identified the proposed allocations that we've identified to accommodate that contribution. What I would also say is that stage 3 assessment specifically considered the results of stage 2A of the site assessment process, and that is the part of the process that Mr. Manley has referred to, where it concludes that P36A is a better site. So what he's saying is because it performed higher against the essay objectives, it's a better site. Now, the whole point of the process that we've undertaken is it recognises there are strengths and weaknesses of any essay process, and it is for that reason that it's essential that there is a planning judgment exercise in that process to layer on wider considerations, and that is exactly what the site assessment process does. So at stage 3, It considers the results of the stage 2A of the site assessment. Those results were considered when we were reaching judgments about which sites we were proposing to accommodate the contributions, but it was considered alongside the other factors that we consider in the site assessment process, and that's resulted in the conclusions in terms of which sites we're proposing to accommodate the contribution.
And just to add to that, obviously Mr. Manley's view, he seems to dismiss, well, not, actually I won't say that. So he seems to consider Greenbelt as an inconvenience, which it clearly is for his site in that context. It is a very important consideration. And, you know, we're all planners in this room, we know that. And that is part of the reason why that site is not proposed. If you want.
Yeah. Well, that's exactly the point that has been irritating me, because we were told that's exactly why it wasn't proposed. You don't know that from reading the essay or indeed any of the documents. All you know is that the site scores very well on any, scores better than the preferred sites, I've said. And we know that it is very proximate to where the needs arise. My point is a simple one. That being the case, there should have been a transparent balancing exercise to see whether or not the site merited Greenbelt release, because this plan is releasing land from the Greenbelt. It wouldn't be a unique experience. And that exercise was never undertaken. All that the dismissal did was point to the fact it was Greenbelt. So Greenbelt was treated as a silver bullet. End of story. And that's my grouse with it. It's my complaint about its inadequacy.
The council want to come back on that.
Yes, if I may, Ma'am.
Matt, I think we've got quite a lot of microphones on.
Is that just me? Yeah, thank you, Mark. Did the essay stage 3 site assessment P36A, which is Mr. Manley's site?
Page number.
Yeah, page number. So it's appendix 379 of the additional essay material, covers the reasoning for the recommendation to retain that land as Greenbelt. So it is, I do not agree with Mr. Manley to say that's not a transparent process. It's there literally in black and white. And the outcome of that process has had to take a view of the council's own evidence on Greenbelt assessment and review, which Mr. Corden referred to early on and gave an explanation about the difference between the two, but that is an essential part of evidence when, particularly when you are proposing some Greenbelt release, which, as you know, we are. And obviously that site assessment has had reference to that assessment process as well. So I do not agree with Mr. Manley's final point there, which seemed to be about transparency of process. It is literally there.
Okay, I think it's probably something we need to go away and read ourselves.
Yes, just
got
for your,
points and
for your
reference.
note, that reasoning is quoted verbatim in Mr. Manley's client's matter, one statement for today, at paragraph 2.38. So it's been, yeah.
So you found it in our transparent documents and put it in your matter statement,
yeah,
and then accuse us of not being transparent. Sorry, I'm sorry, I don't mean to argue, but that's.
We've heard it, what you've got to, both parties have got to say on that. We'll go away and have a read of that, and we've obviously got all the evidence to do that, and others that have been raised today. Okay. Is there anything else on essay that anybody wants to say before we move on to plan period, which I don't expect will take too long? There's a couple of different options in terms of plan period, so it's extend it at the front end, I've got comments from people on that, which we've read. Extend it at the back end so you get 15 years. I've read the comments on that. Is there anything anybody wants to say on any of that, or leave it to us to kind of make that judgment? I think we return to the matters in some way in another session in terms of whether any of that means that you require an early review trigger, because that's all kind of interlinked with that as well, isn't it? But that's probably for another day. We can discuss the trigger option. Is there anything anybody wants to say on plan period that's not already been said now? Okay, thank you. Well, that's helpful. Thanks for everybody's help today. It's not an easy subject, isn't essay, is it? And quite dry. So it's 3:30 now, so we'll take a break for 15 minutes. Probably should be enough. I think there'll probably be less people around the table when we come back, won't there? So I may see some of you again. Probably we'll see lots of you again tomorrow and Thursday, and possibly next week as well.
Can I just be clear? We're going to do the habitats regs when we come back.
Yes.
Yeah.
So we'll have a break, and it allows people to leave if they want to leave. Mr. Cook.
So, sorry, I was making notes when you were explaining that last bit. But did you ask whether there was any comments on the planning period?
Yeah, what I was saying was I think I've read that there are different opinions. So some people want a bit added onto the beginning of the plan, which would start the plan period slightly later. My head's fuddled after a day of essay. It's both ends of the plan period, isn't it, that are up for discussion almost. So whether it should be a 15-year plan period or whether it should start when LHN was calculated in 2020.
Yes, the point that I wanted to make, and I'll do it after the break, if that's okay, was simply.
Are we dealing with that now?
Or doing it now?
Yes.
I think the inspector said that they'd read everything, they'd understood what the various people were saying, and that you didn't need any further just help.
Not unless there's anything anybody particularly wants to say. I've understood there's different camps, if you like. I think it's for us to go away and consider those different options. You know, whether we should have 15 years, whether it should align with LHN.
Fine, okay.
And there's different people got different views. It's normally the case with these things, isn't it?
The only point I was going to make wasn't about adding on at the front or the back end. It was simply on the 15-year point. But if you're taking it away, then take it away. I appreciate it's 3:30.
Yeah. Some people think we should have a 15-year plan period here. Some people say it's not necessary. Have an early review. So we've got the kind of picture, if you like. Okay, so we'll break until 3:45 and then come back and deal with HRA. So if you don't want to deal with HRA and you want to go home, that's fine. Okay.
questions 5 and 6 then, if that's all right. So they relate to the habitats regulation assessment. I'll just read the questions and we'll deal with them both in the round. I think that'd be easier. So what is the latest position in relation to nutrient neutrality? And are there any outstanding objections from Natural England or the Environment Agency to the plan proposals? If so, what are these and how is the council working to overcome them? The second question is the local plan's approach to nutrient neutrality justified, effective and consistent with the framework and the requirements of the HRA? So if we deal with both together, obviously I'm conscious that this matter was dealt with under matter 1 during stage 1 of the hearing. So we have been here before when the issue of the River Clun and nutrient neutrality was discussed. The interim findings in ID 28 indicated that an updated statement of common ground with both Natural England and the Environment Agency should be sought on this matter. There's obviously been some updated work since then. We had an updated position with Natural England in particular, August this year, and that's culminated in an updated statement of common ground, number 15, which is just recently gone on the website. So with that background in mind, could the council just outline the position that's now been reached with Natural England?
Thank you, Mum. Yes, thank you for that. The position, so we've, in our matters report on the, we didn't have the benefit of the updated statement of common ground at that point. That that was being worked on at that point. So the statement of common ground is actually more up to date than the matter statement in that respect. Our position is clear. We have had positive conversations with Natural England, and in a nutshell, that they are content that the on the basis of the proposed main modifications that have been discussed as part of this process to date, principally as part of the stage 1 hearing sessions, that they have removed or can remove their objection to the proposed allocation of the sites within the Clun catchment area. So they had that objection. They are proposing that that is removed, as far as I'm aware, in terms of the statement of common ground.
That's just to be clear then, and that their original objections were about 2 sites in particular only. Is that?
It was only those 2 sites. What was it?
No, so there are only 2 proposed allocations in the Clun catchment in the draft plan. So the Natural England had objected to both of those sites, and they'd raised concerns and objections to the draft policy DP13.
Yeah.
Through the updated statement of common ground, they've withdrawn their objections to both the 2 allocations and also the draft policy. So they have no outstanding objections to the plan. And on that basis, I have chosen not to attend today.
But is that on the understanding though that some extra amendments are made? So there's reference to updating the HRA.
Yeah, so during the original statement of common ground process, we had agreed a factual update to the HRA, which was to specifically recognise the role of salmonoids, the immature version of a salmon, and their role in the life cycle of the freshwater pearl mussel, which is the reason for the designation of the SAC at the Clun. The actual update that we've agreed does not impact on the conclusions of the HRA, but we recognise that it's a factual statement that can be included in the HRA. So within this statement of common ground, we've agreed that when we update the HRA in the context of a main mods consultation, we will make that factual correction, but it does not go to the heart of the conclusions of the HRA. So it doesn't impact on the conclusions that have been resulted from that HRA process. And on that basis, whilst we've agreed to make that targeted update, if you like, it doesn't affect any of the conclusions within the study itself.
Now, I suppose my question was, how is the targeted update going to be required? Where is it going to say that the statement of common ground suggests that there might be an additional or a tweaked on that. The mechanism, do you see what I'm?
Yeah, so obviously we don't propose main mods to the HRA itself because it's not the plan. What we were anticipating is that as part of the any future consultation on main mods, there would be an updated HRA to accompany that consultation document, and in that document we would add in the reference to the role of salmonoids in the life cycle of the freshwater pearl mussels. So that document would accompany any future consultation on main mods to the draft plan.
Madam, you're obviously looking at paragraph 3.3 C in the statement of common ground, where we find in inverted commas the words targeted update. But if you read back to paragraph 2.5, which is matters previously agreed, you'll see the reference again to the targeted update, and it's a targeted update to the HRA that the Natural England are after. They're not after an update to the plan. Now, as you know, you don't concern yourselves with anything other than the plan. But what we have said to Natural England is that we will make the targeted update to the HRA of our own volition at or about the same time as the main mods, so that when people are being consulted on the main mods, they will have seen an updated HRA.
So when you say in paragraph 3.4, as part of the main modifications process for the draft submission local plan, that's an updated, a targeted update of the HRA.
As a factual component.
That's entirely correct.
Thank you. Okay, I'm going to open it up. I've just got one more question on that particular. Both lights showing. Sorry. So you talked about the MMs to the DP13. I think it's 14 now, but it was 13. So that, can you just talk us through what those are and what they do? Sorry, I've got a number if it's helpful. It's MM045 and MM046.
Okay, yeah, Mom, MMO45 addresses the draft policy on development in the River Clun. The proposed main modifications to that policy seek to do two things. Firstly, it's to correct the terminology so that it's uses a phraseology that Natural England are more comfortable with. And secondly, it includes the addition of a third criteria for development within the Clun catchment. So effectively, the first two criteria are that development needs to achieve nutrient neutrality or a nutrient reduction. But that's not a requirement. That's obviously a benefit, but it's not required. It needs to demonstrate that the manner in which that nutrient neutrality is achieved can be secured and funded for the lifetime of the impact of the development. And then the new criteria is that it also needs to demonstrate that that way of achieving nutrient neutrality does not compromise the ability of the River Clun catchment to be restored, to reach favourable conservation status. And in effect, what that means is the Natural England are in the process of producing a blueprint for the restoration of the River Clun. And that will identify the mechanisms that they are going to utilise to achieve restoration. And in achieving nutrient neutrality on a site, they need to demonstrate that it won't undermine that strategy from achieving its objectives. So that's the proposed changes to the policy. In terms of the proposed changes to proposed main modifications in MM046. What they are seeking to do is to provide more clarity in terms of how development can go through that process to demonstrate that they achieve nutrient neutrality in a way that doesn't compromise the ability to achieve the restoration of the River Clun. And it includes reference to a new supplementary planning document that we were prepared based on a lot of the material that's before the examination. So we have, so we've got the River Clun SAC phosphate mitigation solutions for residential development report.
I can reference these as well. There you go.
GC4U to W and Y. And the River Clun nutrient mitigation solutions report, which is GC42A to B. And obviously there is also the activity ongoing at a national level, which is referenced within GC16, which includes the correspondence from government from the 21st of July 2022 about nutrient neutrality and achieving development within catchments such as the Clun.
Okay, thank you. I'm just going to finish my questions and then ask everybody else to join in, just so I've got through them. So the other sort of stem to question one related to outstanding objections from the Environment Agency. So I've read what you've said in your statement. Can you just provide us with any update? Because obviously at the moment, as it stands, there's an outstanding objection from the EA, and there's been the original statement of common ground, which is long. It's just not entirely clear how much agreement was reached with them, and if anything's happened since.
Okay, Mum. I think basically there continues to be objection from the Environment Agency on, we think, a soundness point, which relates to they haven't produced a matter statement for matter one. They have produced matter statements.
They have.
No, they haven't. Sorry, they haven't. So I don't mean to. Sorry, they haven't. Sorry. They have produced matter statements for matter 8 and for 30 on those ones. So we're sort of taking their lead on that, really. Obviously, but I suppose there's some cross-referencing there. So in a nutshell, we have obviously read their matters update. There is an objection from the Environment Agency. We think on a soundness point about how deliverable their version of it is, how deliverable those allocations are. We do not believe, from reading their matters statement, that their objection relates to legal compliance around HRA. You would have, and I would have assumed they would have put, if they did have an objection on legal compliance, which they have not.
So when you say you've read into the sort of around the other matter statements, that's matter 8 and matter 30 that you referred to.
Matter 8 and 30 was related to based on area. Matter 8 and the 30 the environmental policy for the PP 30 14. Hello? Now people hear me now? Okay. Oh, yeah. Okay. Yeah, so I think I heard it that time as well. So we haven't got an update for you on the Environment Agency. They are obviously not here in the room today. We have sought a meeting with the Environment Agency to discuss this issue further. They require payment to do such a meeting under a cost recovery basis. Again, I just need to be careful about how much I say today because they're not here to defend themselves, and I'm conscious of that. This council is not prepared to pay for a conversation of that basis, unless, of course, it was required from a statement from a local plan inspector to do so.
Just a quick question. Were they asked to come to this session today?
We didn't ask them. They haven't put a matters report in. We have asked for a conversation with them about trying to resolve the issue. That conversation happened before they put their matter statement in. We haven't had a conversation since they put the matter statement in. So we'll say their matter statement, which obviously deals with matter 8 and 30, not matter 1, is their most up-to-date position in regard to their objection to the local plan. I would frame their objection as a soundness issue in their version of events. And again, they're not here to articulate this, but it is about how, in their view, how deliverable the sites are in the Clun catchment with the certainty issue or lack of, in their view, of the mitigation measures becoming available in the lifetime of the plan. This was the same issue we effectively dealt with from almost a HRA perspective, and with Natural England. Natural England, through positive conversations and free conversations, we resolved the issue. We have not been able to do that with the Environment Agency. Yeah, again, I think it's probably worth referring to their statement on the matter 1, stage 1 as well, which clarifies, well, in our view, that there's no legal compliance issue which they're raising. It is a soundness point which they are making in their case. So, in a nutshell, we haven't moved things forward with the Environment Agency on their objection, and their matters for matters 8 and 30 are the most up-to-date position that you have and we have in front of us.
So there's no understanding at all of their reaction to what you've agreed with Natural England?
Yes, we know they are aware of it.
That's what, because that mention is made of that, yeah. But that's through a wider group meeting, is it, rather than?
Yeah, we have a liaison group called the Clun Liaison Group, a particularly inventive name, which includes both Natural England, representatives from Natural England, Environment Agency, Severn Trent Water, and ourselves. The whole purpose of that group is to try to talk about these issues. We know that Environment Agency are aware of Natural England's updated position, and I believe they were aware of that before they wrote their matter statement. So,
filling in the gaps.
Perhaps you could take the opportunity of asking them a few questions.
I've made a note.
They're not coming at all.
They're not coming.
They're not coming at all.
I'll ask Kerry to ask them to come.
Yeah.
Cheers.
I think we'll just do what we did before and go around the room. Can I start with you? Sorry, Mr. Cook. It's like we're picking on you.
That's all right. It's better than me at the end and just sort of saying what everyone else has said. Again, I'll be brief and I'll stick to what's in my statement. Essentially, in summary, obviously, you've heard that there are two recent documents to be looking at. One is the August 2024 letter, and then the other is the Statement of Common Ground from the 3rd of October. The long and short of the letter in particular is that a nature recovery blueprint is being prepared alongside a diffuse water pollution plan. And the purpose of these documents is essentially to understand works and mitigation required to negate any harm to nutrient neutrality on the River Clun catchment. The long and short of what's said about that is that Natural England say, considering the timeframes, we have a high confidence in having a restoration plan in place prior to the delivery of the allocated sites within the catchment. And I appreciate that the council and Natural England are now in agreement on this position, but of course you also need to be satisfied that you're happy with the position. And it seems to me that essentially what's being relied upon here is time in order to get these plans in place. There's no, given that these schemes are yet to be costed or produced in any way, we obviously don't have the results, or we don't know what these what the recovery blueprint and the water pollution plan entail. So I struggle a little bit to understand how Natural England can have a high confidence in them, and it's simply relying on time. And you'll see that our matter statement, we've pulled together what we believe to be a schedule of sites that fall within the catchment, and we've had to do that on our sort of looking at various maps and stuff, because I couldn't see a schedule anywhere in the council's evidence. I don't know if the council could confirm whether that schedule is correct, but essentially we understand that there's 229 dwellings that are essentially locked until such time that these plans are in place. And you'll see that the long and short of the point is that we set out in response to question 6. So we essentially feel that this isn't justified, effective, or in accordance with national guidance, which requires a precautionary approach in respect of HRA. And in plain English, what we're saying is that there is no plan B in case these sites don't come forward, because I keep looking back because I'm a planner, unfortunately, and not an ecologist or anything like that. But the nature recovery blueprint and the water pollution plan, there's no plan B if these don't come forward, or indeed they come forward and the answer isn't the answer that the council is looking for. And you'll see in our statement that what we're suggesting, the solution to that is the plan B solution is either make allocations beyond the catchment, or and they should either be standalone allocations or perhaps more appropriately reserve sites to come forward, trigger to be discussed or for the council to decide. But essentially the trigger would be if the sites within the catchment couldn't come forward and couldn't be unlocked through the plan. Thank you.
Thank you. Would the council like to respond?
Yeah, I think so. I do understand the point, and I think Mr. Cook's. I think you've hit the nail on the head. It is a timing issue on this one, and I think we have to be honest about that. We through that club liaison group, we do obviously do a lot of work with them. So we do with Natural England. We understand that work is happening on the recovery blueprint, the restoration blueprint, as it's now known. I just feel as though perhaps some of the points which Mr. Cook's making don't relate to the HRA as such. It's more housing supply in the context of that. Just want to perhaps make a distinction. I understand why you're making it in the session, but perhaps it's the outcome is, we're talking about, introducing the concept of reserve sites because of how deliverable or otherwise an allocation may be. I get the point, but obviously I think the question is more in relation to have we met our legal compliance around HRA issues. But just a point on that point. But I will just, if we are going to talk about that, it's just worth referencing that in our housing land supply, that the assumption around the delivery and the trajectory around the delivery of the sites within the CLON is towards the back end of the plan, and it's done on purpose to give time for that issue to be resolved through that process. So I mean, we'll see where we get to. Obviously, the new national framework has been mentioned a few times today. Look, we're not going to pause local plan making for 5 years. Clearly, that's feels very tempting sometimes, but I don't think we're going to be allowed that blessing. So I don't think we've got anything more to add at this point in time, aside from what we put in.
Can I just clarify on the 229 homes mentioned by Mr. Cook versus the 2 allocations that were the basis of the NE?
I believe that the 229 that Mr. Cook references consist of the 2 proposed allocations that are before you, and then the existing allocations in the adopted plan, the Sandbed plan, of which there are, I think there's 1 at Bishop's Castle, there's 1 at Clun, 1 at Bucknell, and 4 at Lidbury North. Off the top
So I think it looks like an accurate reflection
Yeah,
Yeah, well done.
That's what, yes, that's.
Just in Mr. Cook's statement.
Yes.
Yeah.
On page.
And as alluded to by my colleague, Mr. West, all those sites in our housing land supply and the housing trajectory are expected to come forward from 2035 onwards. What I would say is there isn't a phasing policy in the plan. So if the restoration plan comes forward earlier in the time, then those sites, if they are able to demonstrate compliance with the draft policy, could come forward earlier. What we've done is taken a precautionary approach in terms of our assumptions about when those sites may be developable. One thing I would also add is obviously Mr. Cook said there was no evidence about how mitigation might be achieved. Well, obviously we've already talked about the various documents that the council prepared that look at mitigation measures, and those include costings for those mitigation measures. So there is a lot of evidence on that. The missing piece of the jigsaw at this point in time is the restoration plan, of which work is ongoing by Natural England in terms of the blueprint, and that will be supported by work that's been undertaken by the Environment Agency, as reported to us by Natural England, regarding diffused pollution, isn't it, in the catchments. So there is evidence about mitigation measures, and the restoration plan is being progressed by Natural England, and that is reflected in their position in the statement of common ground.
Okay. Do you have anything else, Mr. Cook, or are we okay to move on?
Not especially, other than to just say that I completely take the council's point on the housing trajectory, which is why I didn't raise it. I know I don't want to stray into other sessions, but I think for me, fundamentally, there still isn't the plan B, and that notwithstanding the trajectory, is that what happens when you get to 2035 and the sites might or could not come forward. And I take the point a second ago from Mr. Corn about a precautionary approach. He's saying that the fact that they are in the trajectory at 2035, that's the precautionary approach. I appreciate with one person's precautionary approach might not be another person's precautionary approach, but for me, a precautionary approach would be to have a plan B, which is reserved sites or safeguarded sites or whatever you want to call them. But no more than that. Thank you.
I am reluctant to stray into other areas, but if you wanted to say something, you can.
Yeah, without straying into other areas, obviously the housing land supply includes a buffer to ensure the deliverability of the requirement. I'm sure we'll talk about that in future sessions, so I won't say too much, but other than the fact that there is a buffer to the supply. I think one thing I would just say, because I don't want to preempt what other parties may say, but as a council, we have a responsibility to consider the needs of the communities within the Clun catchment. And that is one of the reasons why we are proposing allocations within the catchment, whilst recognising there are challenges to development in that location. Those settlements, without additional development, those settlements will not have the opportunity to have new housing to meet their future needs. And the council has to balance the issue of recognising the need to protect the River Clun catchments, but also recognising the fact that we have a duty to look at the needs of the communities within that catchment. And that's what we're seeking to do. We have planned for a relatively low level of growth in the catchment, recognising the constraints, but equally, we do not consider that it's appropriate to simply not allow for any development in the catchment during the plan. And that's why what we consider to be a very cautious approach in the Clun catchment has been taken, which seeks to balance those issues.
Thank you. So I'm going to move to Mr. Wade.
Thank you. Yeah, I think Mr. Cook covered most of the points that we wanted to make, particularly in relation to the use of reserve sites and appropriate trigger for that. But as was being discussed, I think that's probably an issue for a later matter. So, thank you.
All right, thank you. Okay, is there anybody else on the HRA?
I'm only here because I couldn't be bothered to move my computer, and I thought I might learn something, which I have, that you have to pay the Environment Agency to turn up, which is very good. If you don't want them to turn up, don't pay them. It's a simple solution. I might use that myself.
It's not a case, if we want to, it's if we can pay them at the moment. But believe you me.
raise that further.
Okay, so I've got Mr. Roberts.
I'm just used to shouting that. I'm going to be at this examination several times on this particular subject. The last one being when you discuss policy DP 13, I think it is now, isn't it? And some of the things that I might touch on today might be better served in discussion on that day. Can I just understand what the council was saying a little while ago? And they made a distinction between the sites that are proposed for allocation now and what Natural England was saying. I just wanted to make sure that Natural England have got the message that there are newly allocated sites and sites that are saved, and that their comments relate to both. Can I just get that clear before we kick off?
Yeah, through the discussions with Natural England, the total quantum of development proposed in the Clun catchment, which considers existing commitments and proposed allocations, was part of those discussions. So that features in the original statement of common ground. It's also obviously part of the process that the HRA undertakes. So the HRA is not just dealing with the proposed allocations, it deals with the total quantum of development in the Clun catchments as well. So yeah, that was part and parcel discussion. In terms of the previous objections from Natural England to this plan, it was based on the proposed allocations and the policy. Those were the objections that previously raised that have been resolved through the subsequent discussions as drawn out within the updated statements of common ground.
Okay, I've got a few things to say, and if you think they're more appropriate that we discuss them at the time that the policy is under discussion, I'm quite happy with that. We can bring them up again. It's a pity from my side that the Environment Agency are not here, because some of the things that I have to say really involve the Environment Agency, because they issue the licenses for discharge to the rivers, and their actions in this matter are important. Now, the last thing I want the inspectors to recommend is that, because we've criticised the policy, that allocations should be scrapped in this area, because in our view, unless there are allocations there, nothing will happen. And I say that because we've been dealing with this site for getting on for 20 years. It's been in the current examination. It was in the SAMDEV. It was already allocated before the SAMDEV came on stream. In fact, it was allocated last by South Shropshire District Council. There was an application that was approved by South Shropshire District Council, although after some considerable problem getting the consent, actually the bit of paper off them, but they did eventually issue it. But at that point in time, the SAMDEV was coming on stream, and the council wanted to up the number of properties that could be developed on that site. And we thought that was a good idea, because the previous allocation had been for 30 houses, and it was a huge site for 30 houses. The site I'm concerned about, and that we've been dealing with, is a redevelopment site, and it's been partly in railway land. It was a railway sidings, which has now been basically redeveloped for employment, because that didn't require all this nutrient neutrality, and a timber yard. And there was all sorts of stuff in the timber yard, creosote and goodness knows what, and that must have been finding its way into the river somehow. And we thought it would be a good idea to clear everything up. That was a good idea. With the application that we put in eventually was submitted in 2013, and the council decided, without telling us, that they were going to finally dispose of it, the application, in February of 2023. So it had been with the council for 10 years, and we tried all sorts of things to get some discussion with somebody. It was very difficult, and that's why you'll see when I come to my further comments later on, because we never got to speak to Natural England. We couldn't get to speak to the Environment Agency. I did have a little bit of correspondence with Severn Trent Water, but that was mostly on the phone. They wouldn't put anything in writing. And the council were not the most helpful creatures in the world at that point in time. So that's the background against which I'm making these sort of comments. Now then. I've looked through the main modification to the policy, and this idea of nutrient neutrality is perfectly fine as far as it goes. But the question that's been posed on your questions here is whether the nutrient neutrality policy is going to be effective. And it really comes down to what you're trying to achieve by it. And it seems that the main aim is to ensure that the freshwater pearl mussels are not further harmed. That makes some sense. But it does nothing to get houses growing out of the ground, as we've just been hearing from the council. They want to keep them there because they've got a duty to look after the communities as well. So we want the houses, but we also want pearl mussels to come back on stream. Sorry about that. Now, you'll have read that there was a River Clun Catchment Nutrient Management Plan, and that was issued in October of 2014, a year after we submitted our application, as it happens. Now that plan said that they wanted to identify the measures needed to achieve the favourable condition of the River Clun by 2027. Well, we're at 2024 now, nearly 25. And so by that score, we've got 2 years to get the river cleaned up. And that isn't going to happen. It also says, surveys since 1995 have shown that freshwater pearl mussel population is non-functioning. I don't know if you've been going through all this. And may only survive up to, not beyond, but up to another 20 years if nothing is done to improve conditions. Now, that report was issued in 2014, and my guess is they were working on this for some considerable time. That, judging by the thickness of the thing, they must have been working on it for some time. So for the last 10 years, there have been no improvements. And what is now being proposed is that essentially we get another of these nutrient management plans. And goodness knows if it's left to Natural England when those are actually going to be issued. The council aren't going to do their SPD. Yeah. I thought you were going to tell me when. Oh. Sorry. I saw him. And the council aren't going to do their SPD until they've got the Natural England report. So it's all moving further and further back. Now, when they say non-functioning there, the adults were dying and there weren't any juveniles coming through. And if it hasn't got any better over the last 10 years, there's got to be a lot of water cleaning between now and 10 years' time, not in fact running to when these are now allocated for, the houses are allocated for provision. Won't get to that. In order to look at that 20-year period before, according to their original thing, the colony is going to die. Now, we don't, nobody wants that, but we also want the houses. Moving on to whether the changes, the main modifications are going to make a great deal of difference. We've got this idea of nutrient neutrality, but that's for development that's going to take place, presumably between now and 38. But that doesn't get rid of whatever's happening in the river at the moment. That's for new development. And if the water that's in the river at the moment is not favourable to the pearl mussels, nutrient neutrality for new development isn't going to make any difference. So it needs some action to get the water quality that's there at the minute up to speed, up to standard. I looked through that same report, and it seems that the majority of nutrients that get into the river that are causing the problems, 60% come from livestock farming, 5% from arable farming, and then 35% from wastewater treatment plants. And there are several wastewater treatment plants in this catchment. There's Bucknell, there's Bishop's Castle, there's one at Clun, there's one at Lidbury North. There's another one somewhere, but I can't remember. There are another couple in the place plan area, like Cherbury, which flow in a different direction, so they're not contributing to it. But it does seem to me that those wastewater treatment plants, if they're contributing 35% of the phosphate condition in the water, are not doing a particularly brilliant job of it. Now, we do know that the Bucknell treatment plant was upgraded about 5 years ago, and the phosphate stripping in that plant was improved. And you'll have seen some references in Natural England and the council's evidence to say that that has made an improvement. And so the effluent that is being discharged from those works in Bucknell at the moment is much better than it was before. But none of the other works have been upgraded. And so the effluent from those is still flowing through. And the way that the policy is phrased at the moment, saying nutrient neutrality is required for development, won't actually do much for that development that's already been built. So something needs to be added somewhere to put some pressure on Severn Trent Water, who run the works, and the Environment Agency, who license the discharges, to do something about it. Otherwise, the same situation that we've got now is likely to carry on through. Nitrogen is another issue, although that new management plan of 2014 said that it contributes 1% of the problem, and they don't think that nitrogen is an issue for residential development. Same with sediment deposition, most of which comes from farming. And if those are going to carry on in any event, and I know that they've done some effort, they've done some work with FarmScope, haven't they, to try and identify where these problems are, but it needs to go damn sight quicker and and more extensive than it is, because they've not solved the problem yet. And that's the existing problem that will carry on. Just before Severn Trent carried out the improvements to the works at Bucknell, they told us, me, that they were going to divert the effluent from the Bucknell works to another river. And in fact, the river that these works discharge to is the River Red Lake. That runs along one side of a hill, and the River Team runs on the other side. So it was a matter of getting the water over the hill, or the effluent over the hill. Once you get to the Team, the pearl mussels do not live there, and that would have been our solution. And then development could have gone. Now, the same thing's being proposed for Bishop's Castle at the minute, but it goes to another river. And that's good if it comes off, because it hasn't yet been costed or gone through an assessment process. But if it does, that will remove half of the population that go to wastewater treatment plants from the River Clun, because the population in Bishop's Castle is roughly equivalent to all the other populations in that little patch. So that would be a big improvement. Now, why won't, thinking about the housing now, given that that would be a major improvement, why wouldn't Natural England and the council consider it reasonable, as long as you could get nutrient neutrality from new development, to go ahead at that point in time, instead of sitting and waiting for 2038, 35?
Okay, can I?
Please. I'm running out of steam here.
Fine, that's fine. So can I throw that to the council then? There's a lot there.
The answer is simple and can be said relatively briefly. There is nothing that the council can write into its local plan that can require the Environment Agency to issue licenses, or Severn Trent Water to divert water treatment work outflows from one river into another river, or to require Natural England to produce its plan by a particular time point. We wish there was something we could do. As Mr. Corden explained to you, we have the communities within the Clun catchment very much in mind. But we are now persuaded, and we seek to persuade you, that the position for the rest of the plan period is not hopeless. Therefore, we are recommending to you a main modification to a policy which would allow the development to come forward when the law allows it to. The 2014 plan was before the Dutch nitrogen case, and it was certainly before more recent High Court and Court of Appeal cases that made reference to the favourable condition in all important, and an important consideration under the habitats regs and the assessment process. So we believe that there is now sufficient grounds for hope that this matter will be sorted out within this plan period. That's why we have made the allocations we have made. Mr. Roberts needs to be careful what he wishes for, because if anybody casts doubt on that certainty, the only thing we can do in response would be to take, or you could do in response, would be to recommend that the allocations come out, which we don't want either. And therefore, although we could revisit this in the delivery session of housing land supply, we're satisfied that it is What's legally required is what we have proposed for the now DM14, previously DM13. And Mr. Roberts, we say, as a matter of law, ought to be content with that.
Okay, thank you. Mr. Roberts, did you have?
Well, I'm sure I ought to be content with a lot of things in life. No, I do.
Mr. Roberts, you're asking the wrong people. We don't have the power to give you what you want.
Yeah, I can see that. You've got in the one of the main modifications says the council will support the statutory agencies and other relevant stakeholders in the preparation of the River Clun restoration plan. And
it's their plan, not ours. We don't write that plan.
Well, that's right. Why not?
Because the law says that Natural England have to write it.
Why can't the local authority write a plan and say they are Natural England? What about that?
That's not the way it works.
No, I know it's not the way it works, but why not?
We're way off topic really for this session. So unless there's anything specific on the HRA that you wanted to come back on, then I think we'll perhaps park it there.
Well, you've got the drift of what I'm saying.
Absolutely, I've got everything.
I mean, Mr. Richards is quite right. The last thing we want is for you to strike these sites out, because nothing will happen then, and the pearl mussels will go floating off down to Bristol.
Just seemed to me, I was obviously at the last session, Miss Worthington wasn't, but that things have moved on quite a lot. You've made quite a lot of progress, it feels to me. When I read what had happened, it seemed to me that
because people like Mr. West are having these regular meetings with them.
Yeah.
And we'll continue to do that. But the statutory duty to produce the plan lies on Natural England.
Well, which plan? It doesn't.
It doesn't. It's the restoration
rely on
plan.
them to produce this plan.
No, the restoration plan for
the
blueprint.
Okay.
The restoration blueprint. And yes, Ma'am, just to we haven't put it in as evidence. It's hot off the press. I don't want to confuse anything, but that work does continue. There is work happening at the moment that we've commissioned. Has just had a draft report through about actual delivery mechanisms for achieving mitigation measures in the club. It's all right to say mitigation measures. How do you deliver them? How do you fund them? And if I may, obviously, this is a wider point. Is that one of the ways you fund it is through developer contributions, essentially through something like the SIL. What do you need to get the SIL? You need development. So it's a self-fulfilling issue on that. So the benefits of seeking a positively planned approach, and that's our basis for this. As Mr. Gordon has said, we need to plan positively as much as we can within the realms of realism, and we do think we are achieving that within the clun. Mr. Roberts, it's a frustrating picture. It's a complex picture, but the restoration plan has to come before our mitigation measures, which can contribute to nutrient neutrality. That's the position.
Yeah, I don't argue with that. I understand that. We've spent 10 years trying to get some sort of resolution. Local authority hasn't come forward with it. Natural England didn't come forward until basically this plan was in front of them. And
okay, I think we've heard probably all we need to hear. We're sort of just going over.
Oh, I was just getting into the swing of things there.
We're going over things that I think have happened in the past rather than looking forward, which I think is what we need to do.
Well, the important thing looking forward is that council, when they're having their support meetings with Natural England, try to get from them not just nutrient neutrality as far as new development is concerned, but they get action, or keep pushing them to action to get rid of whatever is in the rivers now from domestic places, because they're not the main problem. And somebody's got to take it by the throat.
If I might just try and end on a positive note from this. Obviously, this is being caught on camera today. Your strength of feeling is fairly evident, Mr. Roberts, on this. we share that. We want this to happen.
Well,
I think just taking our agencies, colleagues along with us to show the strength of feeling in rooms like this about the importance of this subject. That is helpful.
we're very happy to come to some meetings because you wouldn't let us before.
You've got my number, Clive.
Thank you. Thanks, everybody. So that's everything I've got on the HRA, unless anybody else wants to add anything. So I think we're finished. We've concluded with matter 1.
Yeah. So we'll call it a day. It's 20 to 5, and see you all. It's 9:30 start tomorrow, so slightly earlier. Okay. Thank you, everybody.